see Mr. Fengelson. I don't know if he, is running. Labor. Good morning, Mr. Ferguson. On the record in the matter, the people of the state of Michigan versus Raymond Baldwin, file number 24-00693, council appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson on behalf of Raymond Baldwin, who's standing to my right today.
How are you, Mr. Baldwin?
Good morning, Judge.
Good morning. Today was the date and the time that was set for preliminary examination. And my understanding is there is a need for a waiver of the timeline.
That's correct, Your Honor. I had a conversation with Mr. Baldwin yesterday and again this morning. Understanding he has met with Matt Samuels and expects to retain Matt. Shortly, Your Honor, we'd be asking for a adjournment of the exam and waiver of the timeline of that opportunity to allow to happen.
Okay, Mr. Baldwin, that's correct?
Directly.
Okay, you understand that you have the right to have a preliminary examination within 21 days of the date that you're arraigned.
Yes, ma'am.
You're willing to waive that timeline so that you can hire a private attorney?
Yes, ma'am.
Okay, is anybody threatening you to get you to waive your timeline?
Okay.
May 16th at 9:30.
May 16th at 9:30. That's court date. If that's a conflict for Mr. Samuels, he can file or get a stipulation to adjourn, okay?
Man knows
Any
how to get a hold
questions?
of us when he comes in.
Just to be clear, Your Honor, that's just a reset preliminary examination date, not a reset piece.
Correct.
Okay, just want to make sure. Thank you.
Thank you. We'll get you your notice to appear.
Ms. Baldwin. Thank you, guys. Have a nice day.
Same to you. So some of jail. As long as it's fine. Jason is in custody. Jason's in custody?
Yeah.
Are they gonna let us bring him up? Are they letting us bring him upstairs today?
They should.
Okay, let's see, are we running an exam on Casey?
Not today, Your Honor. I believe Mr. Casey will be waiving his 21 days, and then we also want to address housing on the record.
Okay, you can bring him upstairs. On the record in the matter, the people of the state of Michigan versus Alexander Priest, file number 23-03532, council appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
I don't see it attorney anymore. Oh, we lost the record on that. Who's representing Mr. Palacio? Is that you? Okay, it says white, but you're filling in.
He had that case of shingles, so.
On the record in the matter, the people of the state of Michigan versus Albert Palacio, file number 23-03335, council appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Good morning, Mike Mataloni on behalf of Palacio.
Okay, let's see. Mr. Palacio, can you hear us?
Hi.
Okay, today's the date and the time that's scheduled for sentencing. I do have a pre-sentence report and recommendation. It was prepared back on March 12th. Did you get a copy of that, counsel?
Yes, I did, and I went over it with my client this morning.
Yes, I did, Your Honor.
Okay, and you need to make corrections, updates, or deletions.
Nothing from the people.
Nothing from the defense.
You can address the court. Sentencing.
Me first?
You or your client, whoever wants to go first.
Okay. Well, I'm asking the court to follow the original deal that we had. That was for him to plead to count 2 use of cocaine and then fines and costs. And I'm asking the court for that because my client's intent was at that time and still is to move to Florida and work out of Florida. In addition, I know on the report, it scores him as a moderate to low risk. Just looks like this is a really poor judgment on behalf of my client, and I don't expect him to repeat the behavior. So I am asking the court to follow that record, or that agreement that we had initially.
Why didn't your client supply a copy of the substance abuse assessment as ordered by the court?
I honestly, I'm appearing on behalf of the White Law Firm. I thought that the assessment was done, it was provided to the court already.
Nope, it says as of this report, it said the defendant completed an assessment at Crystal Ray, but as of this writing, has not supplied a copy to the court.
Speak. I would ask.
Yes, sir.
I can speak, Your Honor?
Yes, you can.
Yes, I did mine on the 8th. They're supposed to fax. And I went down on probation and told them that I finished it and they agreed with it. I talked to the counselor. I was there 2 personal at Kristen Ray, and I completed that on the 8th, and it was supposed to get faxed over. And I called probation right when I was done. I'm finished with everything. They're gonna fax it over. I never knew that myself, Your Honor, but I did complete everything I was supposed to do.
Wow.
My apologies. I didn't know that the assessment had not been sent over.
You don't have it, and I recognize there was a killable agreement, but I have a matter here that involves a plea to use of a controlled substance. And then I have a criminal history, which shows a history of use of controlled substance. So I need an assessment. So I have to reset this. And we'll get you a new date, Mr. Palacio. You sign a release so that your assessment can be provided to probation?
Your Honor, I told them 54 discard, and I called them, and they were gonna fax it as soon as the counselor was gonna send it to a supervisor, and they were faxing it over. I called probation. They said, "Yep, you're all good. You're all set." And I said, "All right, see you in court." And I don't know the misunderstanding. That it was on a Thursday, and they said they send it the first to the beginning of the week because the supervisor had to go over the main counsel. I don't know. I have no clue what happened, Mr. They told me I was good to go. So did probation. I don't know what happened.
Okay, I'll work that out. What time?
No.
April 4th?
Yes.
April 4th at 9 a.m.
All right, thank
Any additional matters for today's record?
Nothing from the people, Your Honor.
I might be late on the 4th, Judge. I have to be in front of the bar at 8:30 in Eaton County. I'll come here right after that.
Sounds good, thank you.
Thank you. And I did text Miss White or Miss Sizemore at the White Law Firm to ask if they had that. So if it happens to come through this morning, can we still perhaps do Mr. Palazzo sentencing? Or did you want to just leave it on for?
No, because probation needs to review it.
Oh, okay.
Yep,
Thank you.
thank you. You're all set today, Mr. Palacio.
Thank you, Mr. Palazzo.
you. All right, thank
Mr. Priest, are you able to find out what happened to your attorney? He was present and then logged off.
I will call him right now for you, okay?
Thank you.
Yep.
Your Honor, my apologies. Mr.
Oh,
Howard
I didn't,
needs to-
I can't see you back there.
Okay, Mr. Howard needs to get to work about 9:45, and we don't have an attorney.
I was just gonna say I don't have any attorneys in here, but if you sit back there, I can't see you. I
Okay.
actually removed the chair that was back there for a reason. I put it in my office because I can't see who's back there. Okay, on the record, in the matter of the people of the state of Michigan versus Don Dwayne Howard, file number 23-03526. Council appearance.
Good morning, Your Honor. Jacob Starr, support Assistant Public Defender here on behalf of Mr. Howard. To the best of my knowledge, the Attorney General has not appeared this morning to the scheduled probable cause conference. Your Honor, I would just request that we just leave the matter on for the preliminary examination. We can treat it like a probable cause conference. I still haven't received any discovery either, so I expect I'll be requesting adjournment at the preliminary examination date at this time. But I'll follow up with the Attorney General this afternoon and try to figure out what's going on.
Okay, we'll continue to the next court date and we'll treat it like a probable cause conference. We'll adjust the timeline as necessary at that time. Do
Thank
you
you,
have
Your
any
Honor.
questions today, sir? Okay, you're all set. Thank you.
Thank you. Thank you, Your Honor.
Thank you. That attorney and find out, the AG and find out why they're not here, why they don't appear. What happened? They didn't let you in? They let you bring up, Lisa? I don't know that Lisa, he's charged as an adult. Yeah.
So, Your Honor, sorry to interrupt, but just so Mr. Flowers is a minor and he's up on the screen with the open court. I just want to, for everyone's covered our butts. I don't know if he's supposed to be visible to the general public.
Charged an adult. To close court, the prosecutor has to send us something.
Oh, understood.
Who's his attorney?
Flowers is
Oh, okay. I saw her, but
she's in Flowers. I can go grab her.
if she's available. Mr. Priest, do you have your hand up?
Yes, ma'am. My attorney said that his internet dropped at his law firm and he's trying to reconnect right now.
Oh, okay, sounds good.
Okay,
Thank you.
you're welcome.
She was not in Flowers. I didn't.
On the record in the matter of the people of the state of Michigan versus Thomas Snyder, file number 24-00676 FY. Council appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Good morning, Your Honor. Jacob Sargent support the Assistant Public Defender here on behalf of Mr. Snyder. Mr. Snyder's present at council table. He's staying in my right.
How are you, Mr. Snyder?
Yeah, how you doing?
I'm well, thank you. Today's date that was set for a preliminary examination. I do have a plea sheet here. It says the people are offering for you to plead guilty to an added count 2 of stolen property, receiving and concealing less than $200 under MTL 750.5355, and they will dismiss count 1. Is that a complete and accurate understanding of the offer?
Yes, Your Honor.
Yes, Your Honor.
You want to accept that offer, sir?
Yes.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes.
You can put your hand down. I have an advice of rights plea information sheet. It's 2 pages. Did you read this document?
Yes.
You understand the rights listed there?
Yes.
Do you have any questions about these rights?
No.
Okay, and this is your signature?
Yes.
Are you willing to give up each of these rights here today in order to accept this offer?
Yes.
So you understand that you have the right to the presumption of innocence.
Yes.
You're innocent until proven guilty, and you have the right to require the prosecution prove your guilt at jury trial by proving each element of the charge being brought against you beyond a reasonable doubt. You have the right to see, hear, or question any other witnesses the prosecution intends to call against you. You have the right to call your own witnesses or present evidence at trial that you believe show a defense of the charge being brought against you. You can remain silent at trial, not have silence be used against you, or you can waive your silence and give testimony on your own behalf at your trial. Do you understand all of those rights?
Yes.
Anybody threatening you to get you to give those rights up?
No.
Has there been any promises made that are not stated here on the record in order to get you to give up those rights?
No.
Are you currently on probation or parole?
No.
You understand that a guilty plea could result in a conviction that you may need to report to your current employer or to your future employer.
Yes.
You also could have impact on travel or immigration status you may be seeking. So you may not be able to travel to certain countries with a conviction of this kind. You understand that?
Yes.
As to the added count 2 stolen property, receiving and concealing less than 200, how do you plead?
Guilty.
Is that because you believe you're guilty?
Yes.
Factual basis, please.
Thank you, Your Honor. Mr. Snyder, back on March 7th, 2024, you had a location, West Holmes Road, South MOK in the city of Lansing, in Ingham County, in the state of Michigan.
Yes.
And on that day, do you have an encounter with a law enforcement officer who pulled you over for a moving violation?
Yes.
And that law enforcement officer advised you that the vehicle that you were operating, which was a moped, turns out it was a stolen moped, correct?
Yes.
And you had reason to believe that moped was stolen because the registration was not in the person that you bought it from, correct?
Correct.
You also had reason to believe it was stolen because you weren't provided with the key. You needed a screwdriver in order to turn the ignition, correct?
Correct.
And you also had reason to believe it was stolen just based on the general condition and other things that would suggest to you that it was probably stolen, correct?
Correct.
And you do believe it was, you do believe that you had reason to believe it was stolen at the time, correct?
Correct.
All right. And this, to the best of your knowledge, is a 2009 Agio moped, correct?
Yes.
And according to the registration, registered owner is Maxwell Harrison Marin, M-A-I-R-N, correct?
Correct.
Okay, thank you, Your Honor.
Any questions from the prosecution?
No, Your Honor.
The court is satisfied with the factual basis. I'll accept your plea. I find it to be freely, voluntarily, and intelligently made. Your matter set for sentencing May 16th, 2024 at 9 o'clock in the morning. When you leave here, you'll go down 1 floor to the 5th floor. You'll check in with probation so they can get you prepared for your pre-sentence interview, okay?
Okay.
Do you have any questions for the court?
No.
You can appear in person or by Zoom for your sentencing, okay?
Okay.
Any additional matters for the record today?
Nothing from the people.
Nothing further, Your Honor. Thank you.
You're all set. Thank you.
Thank you.
That's one. On the record, in the matter of the people of the state of Michigan versus Malcolm Flowers, file number 24-00432, council appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Okay,
If you want to use the flowers,
okay, thank you. Today's the date and the time that's scheduled for a preliminary examination. I had to remand him to the custody last week due to his behavior in the courtroom when he felt like the court should be prepared to move forward with his case, as the court was moving multiple caseloads and balancing getting him upstairs with having other inmates in the courtroom. So the court found good cause to go beyond the 21-day timeline due to that. My understanding is that he wishes to unconditionally waive his right to preliminary examination. Is that correct?
it's hard,
Okay, was there an offer or negotiation will take place at circuit court?
Negotiation will take place at circuit court.
And the people are waiving their right to exam?
Yes, Your Honor, people unconditionally waive their right to a preliminary exam and ask the case be bound over to circuit court.
Mr. Flowers? Okay, you understand that you have the right to have a preliminary examination here in the district court?
Yes,
Okay, you understand the purpose of the preliminary examination?
yeah,
You have the right to require the prosecutor put forth evidence that would establish that they have sufficient probable cause that a crime was committed and then sufficient probable cause to charge you with the crime. Do you understand that?
yeah,
You wish to unconditionally give up your right to that preliminary examination? I couldn't hear you. I can't hear him. Something's going on with the sound.
yeah.
Okay, anybody threatening you to get you to give up your examination? Can you say it again because it's not picking up your sound?
No,
Okay, any promises being caused to induce you to want to give up your exam?
no,
Okay, your waiver is found to be freely and voluntarily given. Your matter will be bound over to the circuit court. Your bind over date is going to be April 3rd. That's the date that they'll get the file from this court. He will not be arraigned unless you make a motion for him to be arraigned at the circuit court, okay?
all right,
So unless your attorney makes that motion, you will not have to appear in court on April 3rd, okay? Do you have any questions?
but I wanna apologize for how I acted the last time that I came to court though.
I appreciate your apology. I understand there could have been some frustration, but understanding that no one had you needlessly waiting. We were trying to get you up here as quickly as possible. And so I appreciate you taking accountability. Good luck to you, okay, sir?
and I would like to address bond.
Yes, to me, have you sign that paperwork first.
Let's sign this, my clients.
Yes, you can sign on this behalf. Did your client leave? Mr. Flowers? I think he left. I don't see him. Mr. Flowers, are you there? He's not there. I'll see if they can bring that on. Oh, I forgot. Use yourself with this one.
That's possible personalities.
Thank you. Okay, Mr. Flowers, your attorney wants to address bond. You can proceed, counsel.
Thank you, Your Honor.
All right.
I don't believe that there was any bond set on this case. I talked to to his mother, and she's willing to have him come live with her. I know he has a pending case in Iona. And we have discussed the necessity of him coming to court when requested to do so. I have known Michael for many years, and his behavior last time was very surprising. We do believe that having him at the jail at this time is not a kind of appropriate place for him. He's 17, and he has a lot of things in his background that that may have him come to be where he is now. He's not a flight visa, and there's stand a charge against him, but he did explain to me why. But we do believe that at this time that this is not that type of charge that does not that warrant no bond, and would ask the court to set an appropriate bond, knowing that
Thank you, Your Honor. I would disagree with Ms. Spongy's statement that he's not a flight risk. He's currently charged as for fleeing the juvenile youth home, and then he additionally has pending charges out of Iona County for fleeing and eluding, causing death. So he's facing incredibly serious charges, and given his history and his conduct, I think that modifying his bond at this point would be inappropriate. If you do find it necessary to provide a bond, then we would be asking for $100,000 cash surety bond with no 10% provision.
A few concerns I have. He was arraigned by the magistrate back on the 27th. She had at least had his criminal history, which I don't have at this time. I have a charge before me that by the mere nature of the charge indicates that he's flightless, escaping a juvenile facility. And then what it sounds like is a connected fleeing and eluding causing death in another county. In addition to that, I think the statement that he could live with his mom, my understanding is that he wasn't living with his mother before this. Is that accurate?
yes.
He was living with his mother or not?
Which mom? Because he has
Well, you said his mom, so I've been assuming it's his mom who logged into our courtroom last week, and I think she might have a court date this week. So which mom are we talking about?
Beatrice.
Beatrice,
Is that his mother or his,
bio mom.
that's the person who logged in last week, I believe. I don't know that, then she has custody of him?
No, her daughter has legal custody, but he cannot live in that. His
Okay.
sister's home.
So you're requesting the court to release him to be with someone who doesn't even have legal custody of him? That bond motion is denied. I think the denial of bond is appropriately set for a number of reasons. A, he is a flight risk, again, inherent by the charge that's before the court. He has very serious matters pending, and I recognize that he is 17 at this time. However, the nature of his behavior, although it was surprising to you, it seems to be unpredictable. And so the court thinks that at this time, it's best that we continue the remand until it can be seen at the circuit court. A bond motion can be made there, and a bond report would be appropriate before any bond is set. Both Magistrate Milmore, at the time of her arraignment, made the determination that he would be remanded, and that she believed him to be a threat to the public, and that he would be remanded at the Ingham County Jail. I also entered an order last week consistent with that, but indicating that due to the nature of his behavior and the allegations of the offending, some of the history of his delinquency in other jurisdictions, that he would not only be remanded, but he will be housed at the Ingham County Jail in the adult detention facilities. So that order will continue. Any additional matters for the record?
Nothing from the people.
Thank you.
Thank you. You're all set, Mr. Flowers. Okay, and we have Mr. Casey. On the record, in the matter of the people, State of Michigan versus Jeffrey Michael Kaysen, in file number 24-00683, counsel apparent.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Morning, Mike Mataloni on behalf of Mr. Casey.
Okay, today was the date that was set for a preliminary examination. Let's see, how are the parties proceeding?
I'm asking the court to allow my client to waive the 21-day rule and accept the preliminary examination.
Okay, why are we waiving the 21 days?
He is prepared to waive that.
Why are we waiving the timeline?
Well, originally the prelim, my understanding was set for Friday, the 22nd, and I'm leaving Friday morning for a week vacation, so I wasn't able to, so we scheduled this so we could waive the 21-day rule.
Okay, so Mr. Casey, you understand that you have the right to have a preliminary examination in this matter?
Yeah.
And that's as to 5 counts, because they're all felonies. And you have the right to have your preliminary examination within 21 days of the date that you're arraigned. Do you understand that?
Yes, ma'am.
Okay, it looks like your probable cause conference, I was notified that the attorney needed a new date, because he has a conflict with the date. Are you willing to waive the timeline so that it could be reset?
Yes, ma'am.
Anybody threatening you to get you to waive your 21-day timeline?
No, ma'am.
May 17th at 9.
Does that work for you?
May 17th.
At
No,
9 a.m.
ma'am. I have a trial in Charlotte where it's gonna like take 4 days. Yes, I can do the 23rd. 8:30.
23rd at 8:30. You can address bond.
If I could, we had a preliminary matter about housing that I might potentially affect how he addresses bond. Is it okay if I address that first?
We had a what?
I wanted to address the issue about custody and housing first, and that might affect the way that Mr. Mataloni handles his.
I was not
argument.
going to address bond until we got to circuit court. I don't believe that I have information that I think would be relevant, but I don't have it today.
You can place your issue on the record.
Thank you, Your Honor. So our office has been in conversation with the Ingham County Sheriff's Office, and the Ingham County Youth Home has informed us that they now have the space and ability to house Mr. Kaysen. So I'd be asking the court to order a change in Mr. Kaysen's housing from being in custody with the Ingham County Jail to a more appropriate placement in Ingham County Youth Home.
Okay, I don't have any information regarding his prior delinquencies, as I don't have his criminal history. I don't have any information other than this file before me. So I can grant your request based on what you both are indicating to the court, that you believe it's appropriate that he be housed in a juvenile facility. Is that your indication and position?
Yes, Your Honor.
Okay. I'll enter an order in the interest of justice, finding that he can be housed in a juvenile facility.
Thank you, Your Honor.
Thank you, sir.
Any additional matters for today's record?
Nothing.
No, ma'am.
Thank you.
Thank
We're
you.
all set. Thank you.
Have a good day.
You too. I can't print the order for some reason. I don't know why. I'm gonna get AJ to come take care of it. See you, Major. Can you print this for me, because it won't, for whatever reason, my printer is no longer linked to the computer.
Okay.
Go to Lord. I'll go together. You're all right. See. That's how you.
Oh. I was gonna say.
Mr. Weesey, are you there?
Good morning, everybody.
Okay, let me find the file. Okay, on the record in the matter of the people of the state of Michigan versus Alexander Priest, file number 23-03532, council appearance.
Prosecutor Petrosky on behalf of the people.
Good morning, everybody. Bill Weesey appearing on behalf of Mr. Priest.
Good morning. Okay, today was the date and the time that was scheduled for a sentencing. I do have a pre-sentence report that was dated, prepared March 12th, 2024. Did you get a copy of that, counsel?
Yes, Your Honor.
I did, Your Honor. I reviewed it with my client. We have no additions, deletions, or corrections to that report.
Okay, you can make allocution.
Your Honor, we're asking the court to adopt the recommendation. We think it's fair and proportionate to this offense and to this offender. An incredibly scary situation over there. Thank God it wasn't worse. But I think the report and the probation department does a very good job of capturing all of the good things involving Mr. Priest as well. He has absolutely no prior criminal record. He has a very good job. He's taken full responsibility for his conduct, expressed remorse, and has demonstrated a willingness to comply with the terms and conditions of probation. I think initially there was a technical bond violation about trying to get a cat out of the residency. Since then, though, there's been absolutely no problems on bond. The parties have seemingly gone their separate ways. Mr. Priest is definitely dotting I's and crossing T's with respect to court orders. And, you know, when we were last in front of Your Honor, you gave me permission to kind of act as a liaison between the parties about some landlord-tenant issues. And I'm happy to report that these two people communicating through me are doing so totally appropriately. That was a very encouraging thing to see. He's a great job, hard worker, and the overall score is moderate to low risk. So based on that totality of circumstances, we're asking that you adopt the recommendation, give him a chance to earn his way out of this. And then the only thing with respect to the recommendation, the no contact order, I would ask that the court make an allowance for my client's landlord tenant attorney, if necessary, obviously, to go through the judicial process to have contact with the victim in this case. Thank you very much, Your Honor.
Thank you. And did your client want to make a statement at all?
I believe he does briefly.
Good morning, Your Honor. Firstly, I would like to apologize to Deshonda that this whole encounter happens. I would like to thank you for everything you've done for me in accordance with the bail violation and the rest of the case. And I look forward to completing my probation, where I will complete it successfully. And I apologize to the state and everybody else that any of this ever happened.
You. And thank you for your candor. I can appreciate that you and with the help of your attorney have been working through navigating the housing situation. I've not had any alerts or issues or concerns about your bond since the time that you retrieved your cat. I have your prior criminal history here. There is no other criminal history noted here. It states here you're a very viable candidate for a term of probation, and you would need to serve a term of probation if you wanted to avail yourself of the special status under 769.4A. So for those reasons, I will adopt the recommendation with modification. Let's see. We'll sentence you to probation, but I think 12 months might be a bit much. and even under the rights to early discharge, you would not have the opportunity to request early discharge. So I'm gonna start you off at a lesser amount of time. I'm gonna start you off at 8 months, and hopefully that will be all that you need versus 12 months. While on probation, the no contact order will continue, but I will allow peaceful contact by way of your attorney for the purposes of your landlord-tenant proceeding. Also, while you're on probation, you're not to engage in any assaultive or threatening behavior. You're not to use, purchase, or possess a firearm, ammunition, or weapon of any kind. You're not to use or possess alcohol or marijuana unless you have a valid prescription, and you will be required to submit to random preliminary breath testing. You're not to be at any bars or nightclubs while you're on probation. You understand that so far?
Yes, ma'am.
You are responsible for the cost associated with doing the random preliminary breath testing, okay?
Mm.
I'm ordering that you maintain your employment and you provide evidence of that to the probation department.
Yes.
I'm not gonna order any programming or treatment at this time, but should the probation department recommend some, then you will participate in that treatment as recommended, okay?
Yes, ma'am.
Fines and costs, there's a $30 per month oversight fee that you would be responsible for while on probation. There's a $75 crime victim rights fee that you're responsible for. That's a $50 state minimum cost. I'll waive discretionary fines and costs at this time. Your total fines and costs will be $365, and you'll make monthly payments on that, okay?
Yes, ma'am.
Have any questions about your probationary term or fines and costs?
I have no questions at this time.
And I've already advised you a portion of your advice and rights as it relates to probation, but except for domestic violence, criminal sex crime, stalking, or offense where defensive guilty but mentally ill was asserted, you would be eligible for early discharge from probation. You would make a request once you had completed half the original term ordered by the court, and then you could hire an attorney to represent you if a hearing was set to address that request. You would not be eligible if you had any violations within the 90 days preceding that request. Your probation officer also could make a request directly to the court for your early discharge if you would be eligible. But again, you are on probation for domestic violence, so you are not eligible to make that early request, okay?
Okay.
You'll check in with probation so that they can go over contact information and make sure that they know how to get in contact with you. You'll have to review the judgment of sentence once they have pulled it together for you to sign and review, and then you'll be reporting electronically, okay?
Yes, ma'am.
Do you have any questions for the court at this time?
No, ma'am.
Okay, well, good luck to you, sir. Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
Nothing further, Your Honor. Have a great day. Thank you all.
Same to you. Thank you.
Your Honor, if people would ask that Joyner be heard in the next few cases and have him be brought up, it's going to be an adjournment request for next week.
Okay, Smith, are we ready with Beckwith?
Yes, Your Honor.
On the record in the matter of the people of the state of Michigan versus Joseph Beckwith, file number 24-00675, counsel appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Your Honor, my apologies. Mr. Beckwith apparently just stepped out and put some change in the meter.
Oh, okay, sounds good.
I did realize that.
My apologies.
Can you bring Joyner up?
Yep.
Thanks. Okay, Mr. Brunette. Anybody here for Dennis Barrett or Stephanie Barrett? Okay, were you able to serve them?
My apologies, Your Honor. Are you addressing me?
That's correct. My last indication in this file was that the parties were not served.
Understood, Your Honor. I didn't have that on my schedule for today, so I think we probably tried to attempt to cancel that with the court. My apologies. I was actually here for Lafke versus a Mr. Ian Smith this morning.
Okay. I'll note that on the file. Is Ian Smith present? On the record in the matter of Lansing Automakers versus Ian Smith. Is that the matter you're referring to?
Yes, Your Honor.
Number 06S03639 GC. I'll take your appearance for the record.
Thank you, Your Honor. My name is Joe Burnett. I'm filling in for Tim Smith on behalf of LAFCU.
Okay, today was the date that was set for a motion to show cause after the defendant failed to appear for a creditor's exam. The matter was scheduled for 10 o'clock. It's 10:18. No one's appeared on behalf of Ian Smith. A bench warrant can issue.
Thank you, Your Honor. If I remember correctly, I believe it's the custom of your court to issue a cash bond for $500, I believe. But I would say that the balance today is $784, and I think if the court was willing to issue a bench warrant in that amount, it could resolve the matter upon his being detained, or however you want to say it.
Yeah, I actually don't. I typically do 5 to 10%, but you can do the full amount on that.
Okay, thank you, Your Honor.
Thank you. Any additional matters for the record?
That is all I have. Thank you again.
Thank you. Mr. Turnwald? Okay, you're here for, is Darrell Davis and Mary Davis present?
Yes, Your Honor.
You completed your creditor's exam already?
No, Your Honor.
Okay. On the record in the matter of Hamilton Road versus Darrell Davis and Mary Davis, file number 23-02985 GC, have your appearance for the record.
Gene Turnwald on behalf of Hamilton Road Limited.
Okay, state your name, sir.
Daryl Davis.
Darrell Davis. Where's Mary Davis?
She was unable to make it.
I don't know if I've ever seen Mary Davis.
She's never been,
Lives in the property?
yes.
Oh, she's a partner. Okay. Today was the date that was set for a creditor's exam. Mr. Turnwall, what's going on?
I've had a chance to talk to Mr. Davis. He's brought no documentation. He does wish to address the court for making an installment payment judgment. Hamilton Road would not be against a reasonable amount of an installment payment. However, we'd like the discovery examination to go forward and see some documentation so we can verify what assets Mr. Davis and Mary Davis has or don't have.
Okay. You understand that you're here for a creditor's exam?
Yes.
So I'm going to swear you in. You're going to go in a private meeting room so you can answer his questions. Do you solemnly swear or affirm the information you're going to provide is true to the best of your knowledge, information, or belief?
Yes.
Okay, you can go and discuss that with them, and then if you all come to an installment payment order, we'll put it on the record.
Thank you.
Thank you.
Joiners.
Beckwith.
Mr. Schwartz is on, yeah, Beckwith.
Yeah, like, more than just my face.
Your attorney for coming.
Okay, well, good.
Excuse me? I didn't hear.
I told him his attorney's
Oh.
coming. So,
Um,
yesterday.
Okay, On the record in the matter of the people of the state of Michigan versus Nathan Joyner Jr., file number 24-00536, council appearance.
Morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Morning, Your Honor. Stephen A. Freeman, Assistant Public Defender, on behalf of Mr. Joyner, who is seated to my right.
Okay, today was the date and the time that was scheduled for a preliminary examination. How are we proceeding?
Your Honor, the people would ask for an adjournment in this matter. We have been here previously on one of Mr. Joyner's 3 cases. I informed the court that there are 2 other ones pending, and the court agreed to set out to handle all of these together. My office signed off on the other 2 cases in February. I just looked through the court view website. The status of them is we are set to come back for preliminary examination in P53 on the first case next Friday on the 28th. This one had been erroneously assigned to Judge Buchanan, and apparently at the PCC last week, they reassigned it to this court, but kept the date the same for today. And then from looking at the records, the 3rd case he was arraigned on is set for a probable cause conference with this court for next week on the 28th with an exam date of the 5th. What I would propose is if we're able to handle all the examinations next week on the 28th, we're moving even the other one up faster for Mr. Joyner. I can make sure that discovery has gotten to defense. I mean, clearly today, I'll email them personally if I have to. I'm not in favor of continuing to push this out, but
Same witnesses?
yes, Your Honor. That's why we adjourned it before.
Okay, counsel?
Your Honor, on behalf of my client, I am obliged to object to the people's motion for an adjournment for the following reasons. Last time we were here, I believe we were addressing file 24-106 FY. That was the first felony file authorized by the prosecuting attorney's office against my client. And part of the reason was to allow the second felony file, 24-536 FY, to catch up, as it were, with 106, so that the matters could be addressed together. On that date, the complaining witness was initially here in the courthouse, but before the 106 file could be called, she left the building and she wasn't available. My understanding is today is the date and time for a preliminary examination as to both files, 106 and 536. I would defer to the court and the official court files to correct me if I'm mistaken, but I believe that we're here for an exam on both of those first 2 files. Now, my good friend and colleague wants to adjourn these 2 files in order to allow yet a 3rd felony file, 24-679, to catch up with the first 2. It's interesting to me because when I compare the dates of offenses in file 106, the date of the offense is supposed to be January 14th of 2024. In file 536, the date of offense, January 6th of 2024. And most surprisingly, in file number 679, the one that is apparently not yet before this court, the date of offense was September of 2023. Now, when you compare the dates of the offense to the dates that the complaints and warrants were authorized, the file 536, again, it states that the date of offense was January 6th of 2024. The warrant was authorized February 22nd. On February 22nd, obviously, the prosecuting attorney's office was aware of all 3 of these files. And then the September 24th date of offense for file number 679 was September of 2023. That complaint wasn't authorized until February 26th, last month. So it is not my client's fault that these 3 separate complaints were generated on 3 separate dates when all of the information from September and January of 2024 were known to the prosecuting attorney when they issued the first complaint. And in the meantime, my client is in jail. I remember being here last time and the prosecutor moved for an adjournment. I objected. The court, in its wisdom, found that good cause was shown, and so adjourned the matter till today. But in the meantime, if he's asking now for yet another adjournment and my client still is in jail, I would respectfully move the court to dismiss 24-106 and as well as 24-536.
I'm sorry, I just need to stop you. There's only one case set for today. It's how do you have grounds to dismiss a case that's not even set for today?
As I said, my understanding was we were here for both. But
We were not. That matter is scheduled for the 28th.
We're talking about 24-536.
24-106 is scheduled for the 28th, which is the same day as the PCC for the file number ending in 679. And there's a bond violation hearing set for that same date. The only matter set for today is this matter. And then the file number ended in 679 has an exam date of April 5th. So I don't have any control over when the prosecution issued their cases, or I don't really think it's the business of the court or even the defense counsel as to when they issued them, long as they were issued within the statutory time frame. They issued within the statutory time frame.
Yes, Your Honor, but my concern, as the court might well imagine, is in the meantime, he's in jail.
If you want to address bond, that's fine, but you went through a whole spiel about when these cases were charged, as if that were supposed to be the basis upon which this court should make a determination as to his bond. And the court doesn't address bond based on when they were charged. We base it on the threat to the public safety, a risk of flight and other factors, but not when the cases were charged. I don't know why the cases were charged in the timeline they were. I know, and I think you're more than well aware that sometimes cases are charged different times because of the investigations that are inherent in them. I don't know how long it took the detective to get the file to the prosecutor's office. I don't know how long it took the prosecutor to get it back to the detective and then to a judge, and then how long the judge, I have zero idea what happened. I know now, though, that there's 3 cases pending, that they're all assigned to me, and that they all have different preliminary examination dates, and I'm not holding 3 different preliminary examination dates. I have one scheduled for today, one scheduled for the 28th, and one scheduled for the 5th. And I'm gonna tell you right now, the 28th is wild already on the docket, so I don't see how we can do, how many witnesses on this?
Across the 3 cases, I'd say 5.
We're gonna run all of them on the 5th.
I beg your pardon, Your Honor. I have a jury trial starting that day in front of Judge Aquilina.
I may have a very similar trial scheduled in front of Judge Aquilina. I will plan on having someone cover for me for that day.
It's the same case.
Yep.
So you guys are gonna be in trial, so we're not even gonna have it on the 5th. That's gonna be beyond the 5th though, because there's no way we can run all 5 of these on the 28th, and we haven't even had a PCC on file number ending in 679, is my understanding.
That's correct. That is scheduled for the 28th. That's why I was suggesting that we potentially hold the exam that day if I get discoveries defense early. But I also was blissfully unaware of the court's hectic schedule on the 28th.
Okay, so the court's gonna find good cause as to this file 536 to go beyond the 21-day timeline. And so, Mr. Joyner, you can stand up. You understand that you have the right to have a preliminary examination within 21 days of the date that you're arraigned?
Yes.
Okay, you were arraigned on this matter on March 4th, The matter was originally scheduled for a preliminary examination today, but for the very same reason why we reset the other one, and the reason why I didn't grant your attorney's request to dismiss the other one for the record is because the victim had appeared. My understanding is that she spoke with defense counsel and then she was missing.
Now, please address the court. Your Honor.
You cannot address the court while I'm talking.
I'm
This is my turn.
Yes, ma'am.
Okay, so the court did not dismiss the case because the victim did appear and I needed to give the prosecution opportunity to re-subpoena. Plus, there was another case at that time in the pipeline. Now it sounds like there's a third case, which was transferred to me, reassigned to me on the 14th per the note of Judge Buchanan, who had originally had this case assigned to her. Nonetheless, in the interest of judicial economy, we will hold one preliminary examination. The court's going to find good cause to adjourn this to a date where both your attorney is available and Mr. Pfeiffer is available, because it sounds like the April 5th date doesn't work either.
Your Honor, to that point, I just asked that we go over Mr. Freeman's schedule. I will.
You're sending someone.
Yep, if need be, I'll send someone from my unit. I do not want to be held up based on my own schedule here.
Okay, and so I'm going to reset all of those exams. I'm going to find good cause in file number 24-00679 to reset the preliminary examination. The probable cause conference will still proceed on the 28th. Not at this time. I'll give you a chance, but we're addressing something right now. What dates work for you for the exam?
Thank you very much, Your Honor. That's fine. 28th. Would that be at 9 o'clock?
No, we can't do the exam on the 28th. I don't think that our docket allows the opportunity for us to have 5 witnesses on 3 cases on this one. Let me see. Your PCC on that is the 28th. I think I have a docket for the first and the second.
There you go.
That's the same person. I have no idea what's going on with this. If we were, we could potentially do it at 1:30 on the 28th. That's up to you all. You want to do it on the 28th?
Yes, Judge, thank you.
Okay, we'll reset them all to the 28th at 1:30.
Perfect. And Mr. Freeman, if you haven't got discovery yet on the newest file, let me know. I'll get it to you immediately.
Thank you, counsel. I believe your office is on top of that. I have. Thank you.
Okay, so all 3 files will continue to exam 3/28 at 1:30. And then your client wanted to address something.
He did, Your Honor. I'm going to encourage him not to. On the other hand, under the circumstances, I was wondering whether the court would be inclined to take a second look at bond and issue a personal recognizance bond for those 2 files.
I don't have the other two files. I have this one, which was set at a 75,000 cash surety bond. Assault with intent to do great bodily harm, less than murder or by strangulation, 2 counts of domestic violence, habitual offender, 4th offense notice, which enhances the penalty to life. I don't know what his bond is on the other matters. Other files. Let's see here.
At the website. Should have.
Actually, Your Honor, in order for him to get credit for time served, I withdraw that last motion, please. Bond as it is.
Record, the newest case is 20,000.
Okay, and there's one that's 20,000, this is 75,000. My records indicate that there is over 10 prior domestic violence incidences in his record. Not necessarily convictions, but some kind of incidents relative to domestic violence. I think bond was more than appropriately set based on the circumstances. Bond will continue. Any additional questions or concerns, sir?
Yes, Your Honor. I just want to speak on my behalf as far as coming to testify at the first preliminary hearing. She did not come to testify. To my knowledge, she came to bring evidence on my behalf for my behalf. And the prosecutor came and presented it like she came to testify, and that was not true. I just wanted to state.
How do you know what she came for?
I was to understand and told by my attorney that she brought evidence to him.
Okay, so what does that got to do with her intent while she was here?
I don't know her intent. I just know that the picture that was painted in front of you was that she came to testify and
she was subpoenaed to testify on that day. She appeared on the same day that she was subpoenaed.
I just wanted to put it on the record that she came to bring him evidence on my behalf.
How do you know? She told you that?
No, he told me that.
Okay, how do you know?
He told me that.
So then you can't speak on his behalf, can you? Actually, it should be the reverse. He's the attorney, right?
Well, he advised me not to speak.
Yeah, you should follow his advice.
You're right, and I apologize, but I just.
Yeah.
I have
It's
not.
not in your best interest to share the information you're sharing. I know
have-
you probably think that you're making a good argument for yourself. Doesn't make you look like you're following the bond conditions.
Your Honor, I just want to apologize to the courts, and I wanted to say that I don't have any good arguments, but I haven't not been charged with something such serious as these crimes, and I'm scared for my life. So I feel like sitting down and not speaking up when I feel like I should say something. I feel like I should. I ask God to bless me to be quiet when I need to be and speak up when I need to be. And that's what I apologize.
Thank you. You need to understand that you have an attorney for a reason. You have a very experienced attorney. Okay, so just because you don't like it when he's telling you that it's not in your best interest, and he can't make you put a muzzle over your mouth, that's up to you. But you should err on the side that he's giving you good advice as a way to protect you. You don't want to have any further charges brought against you, correct? You don't want to say anything on the record that could be used against you, correct? And so maybe you may think that this is good information that you need to share to the court. If you have good information that you want to share, you can tell it to your attorney. If he thinks it's beneficial, I'm sure he'll tell it to the court. If he thinks it could potentially be harmful, and I can tell you what you just shared is something that's potentially harmful for you, he will advise you not to say it, okay? You do have some very serious charges, and right now 3 files that are pending. And so the bond is set to ensure the safety of the public and the victim. And so I think it's appropriately set. Again, the magistrate arraigned you on this on March 4th. She had more information before her than I do, because at least she had your criminal history to review. I have a bond recommendation here in the file. And then obviously information that you have 2 other files pending with the same alleged victim. Bond will continue. We can address your bond again as appropriate at the time of your preliminary examination. Any additional matters for the record?
Just so that way Got all clear from my notes. We're holding the examinations for all three cases and the PA 53 violation on the oldest case next week, 28th at 1:30.
That's correct.
All right, perfect.
Thank
Nothing
you.
else from the people.
Any additional matters?
Nothing further, Your Honor. Thank you.
Thank you.
She's
She's where?
in the back row.
Oh, okay.
But her attorney is not.
Who's the attorney?
Probably, she said.
Oh,
So you're still looking for Raleigh?
Yeah.
He's on his way there. He emailed me.
He is, okay. I
okay,
just wanted to let you know.
Mr. Goodrich. Oh, Mr. Starks, did you find Beckwith? And should we bring up Kindle? Okay, we can bring Kindle up. On the record in the matter, the people of the state of Michigan versus Joseph Beckwith, file number 24-00675, council appearance.
Assistant Prosecutor Jason Petrowski on behalf of the people.
Good morning, Your Honor. Jacob Sarris, Fourth Assistant Public Defender here on behalf of Mr. Beckwith.
Okay, how are you, Mr. Beckwith?
Good.
Okay, today was the date set for a preliminary examination on a domestic violence third offense. How are we proceeding?
It's my understanding that Mr. Beckwith wishes to hold the preliminary exam.
Okay, are we ready to proceed?
We are.
Okay, well, I should have told him not to bring up Mr. Kendall. What are we doing with Mr. Kendall?
We're trying to complete an exam that was previously started. There's two officers that are.
I need someone on the radio and tell him not to bring Mr. Kendall up right now. And I could start this exam, off the record. Okay, on the record, matter of the people of the state of Michigan versus Joseph Beckwith, file number is 24-00675, council appearance.
Prosecutor Petrowski on behalf of the people.
Good morning, Your Honor. Jacob Sargent Fourth, here on behalf of Mr. Beckwith. He's at council table. He's staying to my right.
Okay,
Seated to my right, excuse me.
thank you. Okay, so we are ready to proceed with the preliminary examination. Any preliminary issue before we call witnesses?
Nothing from the people.
Thank you, Your Honor. Respectfully, I would just request a sequestration order. I don't see any other witnesses present in the courtroom, but just for the record, I still like to make that request.
Thank you. How many witnesses do you have?
I have two, yeah, I have two witnesses, one lay witness, one officer.
Okay, sequestration order is granted. You can call your first witness.
Thank you. People call Ms. Tamery Olson. She's on the hallway, so maybe just a second.
Oh, boy. Who's going to jail? That's what I was trying to figure out. No one's there now.
You go to the box that's.
Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, ma'am.
Thank you. You can have a seat there. You can leave your bag on that chair if you'd like. Okay, there's a court reporter that's sitting behind you and a microphone in front of you. Her job is to take down everything being stated here today, so you need to make sure your voice and all of your responses are loud and clear, okay?
Okay.
You also got to make sure you say yes and no, no head nods and shakes, because we can't put that into the record accurately. If there's an objection from either side, you'd stop speaking. I'll make a ruling on that objection, and then I'll tell you if you can give that answer or not, okay?
Okay.
State your first and last name and spell both.
Tamery Olson.
Spell both.
Tamari Olson.
Okay, that's over there.
Oh, I got one too. Okay. Good morning, Ms. Olson. Oh, wait, I'm so sorry. Judge, did you say we're good to proceed?
I was just giving her a moment to collect herself.
Sorry.
No, take your
No
time.
need to apologize.
You can proceed whenever you're ready.
Thank you, Your Honor. So, first of all, where are you currently living?
Right now I'm at my mom's house in Fort Seven.
Okay. Was that where you were living on March 6th, 2024?
Yes.
Where were you living at on that date?
305 Paris Avenue.
305 what?
305 Paris Avenue
Is that in Lansing?
in Lansing, Michigan.
In Indian County?
Yes.
So on the 6th, when you were living at the 305 address, who was also living at that address with you?
Joseph Beckwith.
And what's your relationship to Mr. Beckwith?
Been together for 13 years.
Sorry. Nope, take your time. I'm gonna go off the record real quickly.
Yeah.
Off the record on this matter. Ms. Scheck? I haven't seen Shannon Graham. Have you seen Shannon Graham? Millicent Scheck, are you there? I, 'cause Mr. Turnwall, did you all come to a resolution?
We did, Your Honor.
Okay. Give me just a moment. Ms. Taylor?
Hi there. I had some
Hi, how are you?
complications. I apologize.
Okay. You're fine. You're here for a pre-trial conference with Briarcliff Apartments, correct?
Yes, I am.
I'm gonna put you and the attorney for Briarcliff in a private meeting room. Counsel, you all can complete a joint pretrial statement if you need the court's pretrial form. I can
Okay.
have one emailed to you.
Yes, that's fine.
Counsel, I didn't hear your response.
I do need a pretrial form.
Okay, what's your email?
Elizabeth, ELIZABETH@aaroncoxlaw.com.
Okay, we'll have one sent out to you right now, and then once you get that completed, you can file it on my file. Let's see here. Taylor and Ellison will go in room 1. Ms. Sheck, I don't hear any response from you if you're there.
Your Honor,
Yes.
do we need to come back after I'm sorry, Your Honor, do we need to come back after we submit the pretrial statement?
You'll need to come back if you have an issue. If you don't, you're free to go.
Thank you, Your Honor.
Thank you. Ms. Sheck, no one's appeared today on behalf of Shannon Graham for the pretrial. How do you want to proceed?
Your Honor, I would ask to proceed in a default fashion, and I will explain why. This originally was set for a pretrial a while ago that my office did not get notice, so we did not appear. It's my understanding that Ms. Graham did not appear at that initial pretrial. I then filed a motion to set aside the dismissal. Ms. Graham did not appear at that motion either. We're here today for the third court hearing. Ms. Graham is not here today either, so I don't know if she would ever appear at future proceedings. I would ask to proceed in a default fashion. My client did pray for a sum certain. That amount was $543.29. There's been a $35 filing fee, $20 motion fee. Service was $45.60. There's a statutory $75 attorney fee. Total default judgment would be $718.89.
And your default will be granted and entered as such, and you can file that paperwork on M-File.
Thank you, Judge. Appreciate the court's time.
Thank you. You're all set. Okay, on the record in the matter. Hamilton Road versus Daryl Davis. Counsel, you all have come to a resolution. Can you put the terms on the record?
We have, Your Honor. Today's the day for the discovery deposition of Mary and Daryl Davis. Mr. Davis appeared. He has answered sufficient questions and supplied information about Mary Davis's finances. We're satisfied with the subpoenas have been complied with. Mr. Davis wishes to petition the court for an installment payment judgment of $300 a month commencing on April 1st, 2024, and Hamilton Road will not oppose.
That's correct. You want to do an installment payment agreement where you'll pay $300 a month beginning April 1st?
Yes.
They'll be paying $300 a month on the 1st until paid in full?
Yes.
Okay, you all can complete the installment paperwork and file it with the court.
Thank you.
Thank you. You're all set. Who do we have over here in the corner? We don't have. No, I thought it was Miss Swain. Is the Swain's present? No. Oh, she's in custody.
No, she's in the hallway.
She's in the hallway.
Jacob
Okay.
Rowley, yes.
Gotcha. Okay, but her attorney wasn't here. Is that who it was?
He's here.
Okay, very good. Okay. Back on the record in the matter of the state versus Beckwith. You can proceed, counsel.
Thank you, Your Honor. So, Ms. Olson, on March 6th, were you at the 305 Paris Avenue address?
I did go there in the morning. I spent the night at my mom's house the night prior because of the incidents that happened the night before.
What happened the night before?
Objection, Your Honor, irrelevant.
Section rules, continue.
He took the car and sideswiped it on someone's house. And the car was in my name. So I called the police.
Objection calls for speculation and it's irrelevant for these charges.
What causes for speculation?
What this person did allegedly. She is now alleging that Mr. Beckwith did something else. She doesn't provide any foundation for any reason why she's making this accusation, so it calls for speculation.
That he did something else with her car?
Correct, Your Honor.
Oh, okay.
I did call. the
Object, I
police.
didn't, what, I gave you an instruction about what happens if there's an objection. You have to wait for me to give a ruling, and then I can tell you if you can give that response or not, okay, ma'am? Do you want to respond to the objection?
I can lay further foundation. Otherwise, it's simply just being offered to lay the foundation for,
Objection is overruled.
Thank you, Your Honor. So, I guess when you, the day before when the incident with the car happened, had Mr. Beckwith told you what had happened?
I'm going to object because it calls for hearsay, and Your Honor,
It's the defendant's statements. Objections overruled.
it's in a different case.
I allowed her to lay the foundation. You're giving the same objection to the same testimony 3 times. She's going to be able to lay the foundation. I've already overruled that objection.
Thank you.
The night before, he had been drinking and took the car, sideswiped it on someone's house, so I called the police. That night, I went to my mom's house to spend the night to get away, and I wasn't able to get my work clothes, so that morning I went back with my mom, and so I can get my work clothes, and I noticed he had sold our TV again. I got upset. I went in and I woke him up because this was the second TV that's been sold. And I got upset and I woke him up and I was yelling, "Why did you sell the TV?"
Your Honor, objection, because now we're getting into narrative. And now we're into a different day now.
Objection sustained.
And her statements would be hearsay.
So, I guess specifically then asking you about the morning of March 6th. So, on the morning of March 6th, that was, what did you do specifically on the day? If you have to reiterate what you'd already stated.
I
just-
went in and I woke him up and I was obviously yelling because of the situation with the TV. I just bought it and sorry.
So just so I'm clear, you came home the next morning, you noticed your TV was missing, is what you're saying? Because you gotta get to how you know it was missing. We don't know it's sold yet. We just know that it's missing.
So I guess that's for that morning, you noticed the TV is missing.
Yes.
How did you find out that the TV was sold?
He had admitted to selling the TV.
To you?
I'm going to object, Your Honor, because it calls for hearsay and it's not relevant to the underlying charges here.
How is his statements being offered hearsay?
Because, Your Honor, it's still a statement out of court being entered for the truth of the matter asserted. But in this case, we're talking about a different
Him
element.
taking a TV is being offered for truth of the matter asserted?
Still hearsay, Your Honor. It's
Or
still
is it
statement.
effect on the listeners, is explaining why she did what she did?
Okay.
Objections overruled.
Thank you, Your Honor.
Okay, so then, when I woke him up, I was like, "Why did you sell the TV?" Or, selling the TV again, I'm sorry. And then, I went to get the TV off of the wall and we were both hugging at the TV because I felt like if I didn't get that TV out of there, it was gonna get, that will get sold too. So I went to go get the TV off the wall and that's when me and him were kind of, wrestling over the TV.
Okay, so I'm gonna stop right there and ask some questions. So you stated that initially both of you were had hands on the TV.
I grabbed the TV off the wall mount because I was going to take it out of the house because it's gone, if not. And
Sorry to interrupt, but so when you took the TV off the wall mount, where was Mr. Beckwith in relation to you?
in front of me and
How close?
close enough to phone TV.
Okay, so like within arm's reach? Okay. So then after, do you get the TV off the wall?
I did.
Okay, and so then what, I guess, what does Mr. Beckwith do next?
I'm trying to pull the TV out of my hand. Telling me that I couldn't get the TV. And he proceeded. He got the TV, or he got the TV, I let go of the TV.
When, so when you say that he got the TV, how did he get the TV from you?
And I let go of it because I didn't want to keep, having it being tugged and pulled over the TV. And when I let go, the TV kind of came down on my knee, and the metal thing from the wall mount hit my knee. And that part was over. And he and I both were, or he was also throwing my belongings out of the house, my clothes. And when in the meantime of getting the clothes, I think we both bumped into each other because he did not shove me. But I think we kind of just both bumped into each other when we were trying to go to get my clothes out of the closet. So him, when the police report said that he shoved me down, that was not true.
So I want to talk a little bit more about the bumping that you're describing. So when that took place, where were you?
No, with the TV. Oh, it was the clothes in the bedroom.
You were in the bedroom? Okay. And Mr. Beckwith was also in the bedroom? And
is that a yes?
Yes, I'm sorry.
That's hard to get used to. So when you were both in the bedroom, where exactly were you standing?
I was standing towards the window, or in front of the window, kind of.
Okay. And where was he standing in relation to you?
In front of me, or in front of the closet.
Okay. How far is the closet from the window?
Not very far.
Could you give an estimate in feet?
From right here to probably the between the table.
Okay, so 2 feet approximately for the record. That seems appropriate. So he's about 2 feet away from you. And you said that he bumps into you from 2 feet away?
Well, when we were both trying to get the clothes, I feel like we kind of bumped into each other. But there was no shoving.
Let's describe, or can you describe how the bumping took place? So if you're by the window and he's by,
So when
he's
we
2
were,
feet away.
he was grabbing clothes, I was grabbing clothes. Basically, when we were walking past each other, it was like a shove in the like a bump with our shoulders.
Okay. Who, to the best of your memory, who bumped first?
I don't remember.
What happened after the bump?
After the bump, well, when the TV happened, I'm sorry, he said after the bump happened, I think that's when I went out, or when my mom was outside, she could hear us in there fighting, and I had yelled for her to call the cops.
Why did you do that?
Because when we were fighting over the TV, I just felt like it was gonna escalate more than that.
Why did you feel that way?
Not being the best person lately. Not being my best person. Not making the best decisions when you're drinking into it. So.
Was he under, to your knowledge, was he under the influence of any substances that morning?
I don't know if he was still under the influences. But the night prior, yes.
So
I'm gonna object, Your Honor, for lack of personal knowledge.
the night
Can you ask her if she has personal knowledge, please?
Thank you, Your Honor. The night prior, did you personally observe him consume some substances or witness him under the influence of substances?
Fireball bottles everywhere.
Were they full or empty or? So, and you've been together with him for, you said 13 years? So you know how he behaves when he's intoxicated? Is that correct?
Yes.
And would you say that the way that he was behaving was consistent with that? You're not sure if he still was intoxicated or not on the morning of the 6th?
No, I don't know.
You don't know.
Objections overruled.
So when you're saying that he has not been the best person, there's been some struggles, and then you also called for your mother for help.
Well, I brought my mother with me that morning to get my belongings because that's what the police officer said to do. When I had, talked to the officer the night before about the other incidents, it was best that I went to my mom's house and I had not retrieved any of my work clothes or anything, so I took my mom with me to the house.
And so I guess here, let's see. So when, going back to the process of taking the TV off the wall mount and that whole incident, you said the two of you were tussling, or he was trying to grab the TV out of your hands. Did you do anything else? Did you tell police that he did something else?
I don't remember quite honestly, that morning because it was bad night, that morning. And I don't remember.
Refresh your memory if you saw a copy of the police report.
I did see the copy of the police report. I'm sorry, what was the question again?
Would it help you remember, I guess, what you stated happened if you saw a copy of the police report?
Yes.
May I approach, Your Honor?
Yes.
Your Honor, I would just note for the record that she stated previously that what was in the police report was false.
Well, she didn't say the entire police report was false. She said that the portion about him pushing or shoving her down was false. So,
well,
that doesn't make the entire police report false.
I suppose, Your Honor, just to preserve the issue, I'm going to object on this refresh on the ground. She's already testified regarding involving television that she believes that what was in the police report.
Okay, thank you. Objections overruled.
The statements you made are on the third page. When you're done reading them, you could just look up and let me know. Hold on. So, what did you tell the police had happened?
I told them about the wrestling for TV and when the metal piece came, like when I let go of the TV and the metal part had hit my knee. I told them that, and I never said that he shoved. And I never said that there was another part on there. I can't remember. I'm so sorry. Can I see that again?
Yes, yeah, for Manager, Tran.
Do it.
Says when he came up from behind and pushed her down, hurting her knee. That is not true either. But that's not true.
And so it's not true in that you didn't tell police that?
I'm sorry.
Did you, so are you saying that the,
Yeah, I did not say that to the police.
so after the bumping incident took place, well, actually, I want to talk about that a little bit. When that happened, do you remember where, could you see where Mr. Beckwith was looking when the bumping happened?
Yeah, no, where he was looking.
Yeah, like, was he looking at you? Was he looking out the window? Do
He
you
was
remember?
just trying to grab my clothes to keep taking them and throw them out the back door.
Were any of the clothes that he was grabbing in your hands while he was grabbing things?
Yeah.
And then you said that you called for help and your mother called police.
Yes, she did not see anything. She just heard me yelling when we were wrestling over the TV. And she called the police. I yelled for her too.
No further questions.
Cross-examination.
Thank you, Your Honor. So Ms. Olson, just to clarify, the morning of the 6th, so before approximately 8 a.m., you weren't at that location that night into that morning, correct?
No, because I stayed at my mom's house from the night and the stuff that happened the night before.
Okay. You stayed at your mom's house, and do you recall approximately what time you went over?
To my mom's house?
No, to 305 Paris Avenue?
At night or the morning?
The morning.
It was before work, so it was probably about 7:45, 8 o'clock.
Okay. And just so we're very clear here. Person that you've identified here is Mr. Beckwith. He did not threaten you, threaten to punch you, or do anything along those lines that morning, correct? He did not
threaten to punch me or no.
No. Okay. You described an incident of bumping, excuse me, bumping regarding the clothing.
Is that a yes?
Yes.
To the best of your knowledge, was this accidental, possibly?
Yes.
Okay. So to the best of your knowledge, it wasn't an intentional act on his part, correct? And in terms of the television, you both were going for the television at the same time?
No.
No.
I grabbed the TV off of the wall.
Okay.
And that's when he was trying to take it out of my hand.
Okay. But he was grabbing for the television, correct?
That I had in my hands, yes.
Okay. But at the time, you were not in fear that he was trying to attack you or anything along those lines, correct?
No.
So, to the best of your knowledge, his only intention was trying to try to get the television. You know, okay, but.
Or to, I'm sorry.
That's okay. You don't believe that the actions with the television were directed at you, correct? You were never in fear of him attacking you when he was trying to.
I didn't think he was gonna grab, I mean, I wanted to get the other TV out of the house, I mean.
Okay, so it was just about the television, correct?
Yeah.
Okay, so you never felt that he was trying to attack you when he was reaching for the television, correct? And in terms of your need, did you ever?
But why would I feel that? Why would I think that he would have?
Thank you. No, you answered the question. I appreciate it. I just asked you whether at the time you felt.
I've been with him for 14 years, sir. Obviously, I'm not gonna feel threatened all the time because I love him. So when I go to grab the TV off of the wall because the other TV was sold, why would I not want to get that out of the house so that way none of the rest of my stuff becomes up next?
Yeah, I don't think, he's not asking that. He's really trying to figure out if you felt in fear that he would assault you during that time.
No.
That's the question.
And thank you for clarifying. That's all I was just trying to sort out. When he was going through the television, you did not feel that he was trying to attack you in any shape? Okay, thank you. I appreciate that. And in terms of your knee, did you ever seek any medical treatment for it or anything along those lines?
No.
Okay. And just to be very clear, you injured your knee, but that was after you had recovered the television at that point, correct?
I was never able to recover the TV. I let go of it. And when I let go, it hit the corner of the metal piece that hangs on the wall. That's on the back of the TV. Hit my knee.
Okay, but you don't think that was intentional by Mr. Beckwith, correct? You believe that was just kind of an accident?
I don't believe that was intentional. No.
Okay, thank you. And just so the timeline is clear. So from approximately from March 5th until the morning, how long were you out of the location 305 Paris Ave?
Well, when I crashed the car, I had to have been in between 8 and 9. Well, I went to my mom's house about 9:15.
So you were out of the air, you were out of that location for about 11 hours or so, 10 hours or so?
Yeah.
Okay, thank you. No further questions, Your Honor.
Redirect.
Thank you, Your Honor. So first of all, I realized that I interrupted myself when we were talking about some, how you know Mr. Beckwith. Would you recognize him if you saw him today?
Yes.
Is he here in the courtroom? Can you describe where he's located in regard to what's happening?
He has a gray that I bought him.
Let the record reflect that Ms. Olson's identified the defendant.
Identification's noted.
So I have a couple questions. When Mr. Starks was asking you about the bumping while trying to remove the clothes, he said that the bumping was accidental, but there was quite a bit of hesitation. Why did you hesitate?
Because I don't think it was intentional that we bumped into each other. And I don't want someone to go to jail for something that, that wasn't true. And well, I'm just thinking that part was not true. Because I just feel like we were just walking past each other and, bumping shoulders because our room's not that big and I'm trying to grab my clothes. He's trying to grab my clothes, put them outside. And
was he upset with you at the time? Yeah. Was he yelling at you?
I wouldn't say he's yelling at me because he had just woke up because I woke him up because I was upset. TV was gone again. And so I woke him up. And then that's when everything started happening. I'm like, why would you throw the TV again? Just stop.
Just got a couple more questions, guys. So, when you were holding TV was in your hands, correct? And then you said that he was trying to take it from you.
He was saying I'm not taking the TV.
And can you describe how he was trying to take it from you? Like what his actions were?
He was in the front of me. And I had the TV right here. And he was trying to pull it out of my hands.
And did you want him to do that?
No, because I wanted to take the other TV to my mom's house, so I know that wasn't another item in the house that was going to be gone.
And you said that eventually you let go of the TV. Is that correct? Yes. Would you have let go of the TV if he hadn't also been grabbing for the TV?
No, I would have put it in my car. I don't know.
Any additional questions for, well, actually, I think I have a question. You previously testified on your direct that you yelled for your mother to call the police during this incident. But then on cross-examination, you answered Mr. Stark's question and stated that you didn't feel that you were at risk for him attacking you. So can you explain to me why you wanted the police called?
Well, when we were wrestling for the TV, that's when I kind of felt like more being, like I was being more attacked and I was wrestling when we were trying to grab the TV.
Okay.
So then my mom, because she didn't come inside, she could just hear what was going on outside, and then that's when or inside, so that's when I said, Mom, please call the cops.
Okay. Any additional questions based on my question?
Briefly. So you, when you answered that question, described what was going on as wrestling. What is wrestling?
Maybe I don't know if I'm technically wording it right. I don't necessarily think that we were wrestling over the people. We were rolling around or anything like that, but fighting, pulling, tugging for the TV.
And during that, at any point did he touch you? Not even on accident? Further questions?
Mr. Starks?
And just to clarify, you don't believe he was trying to attack you, correct? He was just trying to get the TV?
I don't feel like he was trying to attack me, but in my eyes, I should have been able to take the TV without being wrestled or, without having it being tugged out of my hand.
Okay. So your understanding, the two of you just had a disagreement over the television, correct? Thank you.
Ms. Witness, be excused.
Yes, she may.
Thank you. You may be excused. There is a sequestration order, so you're not to discuss portions of your testimony with any other witness, okay? So is that a yes?
Yes, I'm sorry.
No problem. Thank you. You can be excused. You can call any other witnesses at this time.
Thank you, Your Honor. The people call Officer Mark Fox. Oh, look at him.
You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
I do.
Thank you. You can have a seat. Please state your first and last name and spell both.
Mark, M-A-R-C, Fox, F-O-X.
You, counsel, you can proceed.
Thank you, Your Honor. Good morning, Officer Fox. How are you?
Good morning, I'm good.
So, where do you work?
Lansing Police Department.
And what are your duties?
I'm a police officer on patrol, so patrol the city during the day shift hours.
Were you working in that capacity on March 6th, 2024?
I was.
And on that day, were you dispatched to 305 Paris Avenue?
I was.
And what were you dispatched for?
I was dispatched for an assault complaint.
What were you wearing on that day?
A full uniform and driving a fully marked patrol vehicle.
And so did you go to 305 Paris Ave?
I did.
And what did you first observe when you arrived?
There was a woman and her mother standing outside the house. They were very distraught over an assault that had happened recently.
And did you make contact with those two women?
I did make contact with both.
And did you notice anything notable about either of them?
I spoke with the victim, Miss Olson, and she had her jean pulled up and a red mark on her knee. And she stated to me that she had gotten or had been assaulted.
Objection calls for hearsay.
You want to address the objection?
Thank you, Your Honor. I will be, I'm in the process of laying the foundation to proceed victimless under MCL 768-27C. I can have him address these issues at a later time, but this is just the process of getting to that point.
Your Honor, plaintiff witness has already testified that what she told the officer was false.
Yes, I already testified where you laying foundation to proceed victimless.
Because I believe that there were some discrepancies between what police were informed and what police had observed that night, and then between the testimony of Ms. Olson today. So
illicit testimony, but you're not victimless. Your victim appeared and gave extensive testimony. So the objection is sustained.
Thank you, Your Honor.
Do you know what time the call was made?
The initial call in the morning?
Yes.
I want to say around 7 a.m. the call was made, but I can't be positive of that.
Okay. Do you remember how long it took for you to respond to the call and arrive at the address?
Approximately, I would say approximately 10 minutes between the time I was dispatched and the time I arrived. I had to sit and wait for my backup.
Okay. And when you arrived at the address, you said that the two women you observed were distraught?
Yes, they were distraught.
And how would you describe, or what made you think that they were distraught?
First and foremost, they were both talking to me at the same time about an assault that happened.
Oh, and I just want to interrupt. If you can describe this without getting into getting into what they said.
So the Miss Olson's pants, one of her jeans was pulled up above her knee. And she was speaking very quickly. She was crying, or she had been crying, I could tell at some point in time during the interaction. She was very up and down when she was speaking to me. So she was elevated, and then she would come down and talk to me in a normal tone, and then be elevated again when she spoke about things that happened. So she was very upset about the whole situation, and apparently upset about whatever had happened the night prior going into this day. So.
And so when she's very upset and she's speaking to you 10 minutes after the call was made,
yeah.
Did she describe what happened?
Yes, she did.
And what did she say happened?
Objection calls for hearsay.
At this point, I would say that the statements would fall under the exceptions to the rule against hearsay, specifically Rule 803, 2 excited utterance. This was the statements made by Ms. Olson were approximately 10 minutes after the incident, after the police were called, which happened immediately during or following the incident. And Ms. Olson, based off of the testimony from Officer Fox, was clearly under the excitement of the incident still. She was, as he described, distraught, crying, unable to regulate her emotion while speaking to him, going from in different tones. So I'd say that this would fall under that exception.
I would agree. I also think that she's trying to address credibility of her first witness, so I'm going to overrule the objection.
Thank you.
So when speaking with Ms. Olson, what did she say happened?
She told me that she had gone to her mother's house the night prior. She came back to the house to get her effects that morning. And when she was in the bedroom with the defendant, getting stuff out of the closet, he pushed her down, hurting her knee. She then said the verbal argument continued, and she tried to take a TV off the wall that belonged to her. And while she was taking the TV off the wall, the defendant came up from behind her, grabbed her around the waist and wrestled her away from the TV.
Did she say at all whether she wanted him to do those things?
She did not. She did not say that she wanted him to do those things.
Okay, thank you for the clarification. And did she say anything about her physically attacking him or threatening him in any way?
As I recall from the interview, she was there to get her things out of her house because she didn't want to be in that house and was going back to her mother's house.
Okay, so to your recollection, then no, she did not attack him?
Not that I recall.
Okay, no further questions.
Cross-examination.
So just to clarify briefly, officer, she never told you that any of her encounters with Mr. Beckwith were without her consent, correct?
I'm sorry, can you say the question again?
Yes, she never said that the interactions with Mr. Beckwith were without her consent, correct?
You stated to me that he's the one who attacked her in her house.
Okay, but she never said the physical contact was consensual or it was not, correct?
No, she never stated whether or not it was consensual. No.
And you recall what time you talked to her?
She was the first person I talked to. I believe I responded to the call around 7 a.m. and she would have been the first individual on that scene that I spoke with. So maybe if I respond to around 7 a.m., maybe within 2 minutes of arriving at the house, getting out of my vehicle and walking over to her, she's the first person I spoke to.
Okay. And to the best of your knowledge, she didn't need any medical treatment or anything like that from Nate, correct?
Yes, I asked her and she declined medical treatment.
Okay. Nothing further, Your Honor, at this time. Thank you.
Redirect.
No redirect.
Thank you, officer. You may be excused during the sequestration order, so you're not to discuss your testimony with any other witness. Thank you. Proceed, counsel.
Thank you, Your Honor. So people rest at this time and then make argument for bind over.
Thank you. The defense calling witnesses today.
No, Your Honor, thank you.
Bind over argument.
Thank you, Your Honor. Mr. Beckwith is charged with the crime of domestic violence, third offense. I'm taking her testimony from Ms. Tamara Olson, his longtime dating partner and person that he shared a residence with, and also testimony from Officer Mark Fox. The testimony from Ms. Olson differed substantially from what she had previously stated. However, even with even with the variation of her testimony from what she had previously stated occurred, I believe still that the elements for domestic violence were still satisfied, as the defendant would have to forcefully, violently, or offensively touch a person or something is closely connected with him or her. My apologies that I don't have the exact case in front of me, but I believe it's fairly well understood that things that are in someone's hands or things that they are holding onto are considered to be closely connected with him or her or with their person. So by offensively trying to grab the TV out of her hand, which she stated was against her will, and was against her will and was done forcefully, she wouldn't have let go if he had not been grabbing against her or grabbing in opposition to her. I believe that her testimony there in and of itself satisfies the element for a battery taking place along with the domestic relationship existing. And she also testified that she identified Mr. Beckwith and that the assault took place at the 305 Paris Avenue address on March 6, 2024. Additionally, Officer Fox testified that when he responded to the call, Ms. Olson was distraught and described that she had stated to him that the defendant had pushed her down and had touched her in a way that she had described as being attacked. While she didn't specifically state that she was that it was non-consensual, I believe from the language that the language that he was able to relay to us today, that would speak to the intent and the forcefulness of the battery. So at this time, I would move the court to find over on the charge of domestic violence, third offense. And because the elements have been proven to a probable cause standard and any discrepancies of fact can be decided by jury trial.
Mr. Simmons.
Thank you, Your Honor. Defense would move to dismiss at this time. Respectfully, people have not met their elements as required to request find over for the purposes of today's plenary examination. Your Honor did have the opportunity to hear directly from Ms. Olson. I think she made it very clear based on her testimony that her original statements to the police were false or misconstrued by the police officers. She describes a situation where basically two adults were just arguing over some personal stuff, some personal items. Your Honor, respectfully, she made it very clear that she never felt that she was in any danger of any sort of imminent battery. She did not believe the actions were intentional by Mr. Beckwith in terms of being directed towards her. Respectfully, testimony here would, at best, in the light most favorable to the prosecutor, reflect perhaps a tussle over some personal items, but certainly would not arise to allegations of any sort of domestic assault or domestic battery. And Your Honor, respectfully, based on the testimony here, the defense would request this case be dismissed. Thank you.
Thank you. Today was the date set for preliminary examination on one count of domestic violence for third offense notice. The burden is on the prosecution to establish they have sufficient probable cause that a crime was committed and then probable cause sufficient to charge you with the crime. They need to give more than mere suspicion that a crime was alleged, but they don't have to prove each element beyond a reasonable doubt. The court will be the sole determiner of the credibility of the witnesses, and the court will also weigh the likelihood of the people's success at a trial. Today we had testimony from a Tamari Olson, who stated that on or about March 6, 2024 at 304 Paris Ave, City of Lansing, Ingham County, State of Michigan, making venue in this court appropriate, that she returned to her home or at that address after spending the night out due to some ongoing issues with her and the person she described herself to be in an intimate relationship and identified in the court as Joseph Beckwith. She stated that when she returned, the TV was missing, and that she stated that the defendant told her that he had sold the TV. She was very upset. I will also note that she was very upset every time she brought up the TVs today. So there must have been some issue going on with the TVs, but nonetheless, she testified that she went to get a TV off of the wall, that she had the TV in her hand when the parties began to wrestle over the television. That was exactly her testimony initially on direct, that the defendant tried to pull the TV out of her hand and that eventually she let the television go. She said when she let the television go, the TV came down on her knee, and I think that it was the bar or something that was used to help mount the TV and ended up falling on her. She stated that the defendant began grabbing her belongings to throw them out of the house. She at the same time was trying to grab her own belongings too, which is the reason why she stated she was there. They were in the bedroom at that time. She described the bedroom to be a small space. She testified that although the police report may have indicated otherwise, she believed in fact that they bumped into each other due to them moving so quickly beyond each other. She testified that during the incident where they were tussling, tugging, or trying to get the TV from each other, that she yelled for her mom to call the police. And she said that she did that because she thought that the matter would escalate because of him not being the best person lately, is how she described it, and that he had been engaging in some uses of substances. When questioned as to how she knew he had been using or drinking alcohol the night before and or the day of, she stated that there were Fireball bottles everywhere, that she had been in a dating relationship with him for approximately 13 to 14 years. She is aware of indications as to how he acts when he is under the influence. she did not believe him to be under the influence when she was home that morning of March 6th. On cross-examination, she again restated that she did not believe that he pushed or shoved her down, and that he didn't intentionally bump into her. The question before the court is whether or not the actions that took place during this interaction result or rise to the level of a domestic assault. I specifically questioned Ms. Olson, and we did have testimony also from Officer Fox. I found the witness's testimony to be largely credible. I don't believe that she gave any intention to lie. I don't even think that her hesitations were something that would be attributable to her being either apprehensive about telling the truth. I think she wanted to give some clarity and be careful about how she described the incident. She was very emotional. She seemingly broke down every time she mentioned those TVs being sold. So something was going on that triggered her as it relates to those televisions. She was candid when she stated that when she noticed the TVs were missing, she got upset. And she went to him to talk to about or yell at him about the TVs. However, the jury instructions are very clear. It states in order to prove this beyond a reasonable doubt at a trial, it says that a battery is a forceful, violent, or offensive touching of a person or something closely connected to her. A touching must have been intended by the defendant, that is not accidental, and it must have been against the complainant's will. The prosecution is arguing that the television being in the possession of the victim at this time would constitute something closely connected to her. The court would agree. I think that's the classic definition of what's closely connected to you. Something that is in your hand that you're holding and someone tries to snatch it out of you would give rise to an assault. It can't be accidental, it says. Well, I don't believe based on the testimony that the defendant would have accidentally been trying to snatch the TV out of her hand or tug the TV away from her. Also, I want to highlight again that the court had to ask her about why she called the police because it became unclear during the cross-examination as to whether or not she believed there was a threat, although she had stated on direct exam that she had contacted the police or had yelled for her mother to contact the police. And she stated that the reason why she contacted or had her mother contact the police is because at the time in which he was attempting to take the TV from her, she, in her words, I quote, felt more attacked. The court is satisfied that there is sufficient probable cause as to count one of domestic violence, third offense notice, a felony 5 years and or $5,000 that will be bound over to the circuit court. The date is going to be April 3rd. That's the date the circuit court gets the file from the district court. You do not need to appear in circuit court on that date unless your attorney is making a motion for you to be rearranged for some purpose. Nonetheless, without that motion, your next court date will be a pretrial in the circuit court. Mr. Sarge will be made aware of that date, okay? I'm talking to you, Mr. Beckwith.
Oh, yes, ma'am.
Okay.
Yes, ma'am.
I have a phone number for you ending in 2011. That's still accurate?
Yes, ma'am.
And you're staying with your grandmother still?
Yes, ma'am.
Okay, you will keep the court updated on any changes in your address. I don't see any issues with bond at this time. It was originally set at 5,000, 10%. No contact order in place. I have no indication of any violations. Any additional matters for the record, bond will continue as set.
Nothing from the people, Your Honor.
Nothing from the bench, Your Honor. Thank you.
Thank you. You're all set.
Your Honor, if I could just take a second and speak with defense counsel in the hallway.
No problem.
Thank you.
Is Mr. Raleigh here?
That's what I'm getting to.
Oh, for sentencing?
he said he wanted to talk to me, so I was just gonna do that.
Okay.
That's what he told me. So I try to get him in here. Give me a bit, Mr. Kendall.
Well, I don't really know what's going on. The person who's supposed to be sent, I was gonna say we're resetting them because I guess he changed his mind. Let me call this case on the record in the matter of the people of the state of Michigan versus Lisa Lene Swain, file number 23-00043 SM, appearance for the record.
Thank you, Your Honor. Assistant Prosecutor Paige Petrowski on behalf of the people.
Assistant Public Defender Jacob Riley on behalf of Lisa Swain.
Ms. Swain, how are you? I can't hear you.
I'm good.
Okay. Today is the date that we reset your sentencing. You were supposed to be before the court on sentencing back on December 4th. You never appeared. Why is that?
I left the court paper at my kid's dad's house and I moved from there. And I just totally forgot.
Okay. You totally forget that you were supposed to be screened by the probation department before a sentencing date.
No, I didn't know his.
When did you do that?
It was I mean, it was one of the last times I was in jail. I don't remember the exact date, but I know I didn't PSI.
You were just in jail in this month, correct?
Yes, I'm talking about last year. I didn't PSI.
No, you didn't. You hadn't even taken a plea in September. Well, you took it September, you pled guilty September 25th. I reset your sentencing. It looks like November 15th, and then you were supposed to appear December 4th. And I see March 13th, you were told that you needed to meet with probation because we still don't have a pre-sentence investigation. And so if you took a plea on the 25th, which is towards the end of the month, you would have had to report to probation within 48 hours for you to complete paperwork for them to then do the interview. So you're telling me in 5 days left in September, you did all that and had the interview in September?
I did a PSI, yes. I seen the judge when I was down in jail on Polycom help with lunch, I don't know her name. And she asked the lady that was sitting there, did she need another PSI for me? And she didn't say anything.
So you have another matter pending at the same time as this?
No, it was for this. It was for the.
What judge did you see? I'm not.
It was a
following.
magistrate, I believe.
You're talking about,
I believe it was March 13th.
okay. I see you saw Judge Buchanan on the 13th.
Yes.
She had a PSI done last year, but nothing recent.
When, in September?
It looks like the email to the defense attorney was sent November 14th.
I do have that PSI dated November 13th.
You have, oh, so you have a PSI. I don't have a PSI.
Also don't have a PSI.
Someone's gotta get probation up here. You have a PSI in the email?
From last year, yeah.
Well, I knew that. I don't know why they didn't send a probation file with a
That's what I was
sentence
thinking.
packet, nothing. You can have a seat, ma'am.
Ms. Nash, could you also send that to me when you get a chance?
Yeah.
Appreciate it, thanks.
Bringing Kindle up, that's the last criminal file today, I think.
For the morning, there's PCCs this afternoon.
No, you can have, you can stay right there.
I'm sorry.
I suppose.
The PCCs, it looks like
You can go to the jury box.
Two of them were just left set for prelim, and then I have the names of the other ones that I'm not sure how wasn't wants to proceed.
Which one?
So for Hidalgo and Johnson, both I've received emails from both of those defense attorneys that those are just being left set for prelim.
Okay, Johnson's continue.
And Hidalgo. And then,
Oh, I see Hidalgo too. Continue.
and then Pendes and Carr, I have not received word from the attorneys on those cases.
Yeah, it looks like Pendes needs a Croatian interpreter. You said in Hart?
Carr.
Carr?
The other PCCs I believe are covered by vertical attorneys, so.
Carr? What time is Carr?
Oh,
Or Har?
excuse me, I got them flipped. Yeah, it's Cody Har, not.
Oh, okay.
Sorry about
Is
that.
continue?
I'm not sure how.
Oh,
to
okay.
proceed.
We know what's going on with Brown.
That is a case for Mr. Pfeiffer.
Okay. And Hart?
Hart is another Pfeiffer case.
Okay. Pfeiffer. And this must be an AG case. And-
Timothy King and Justin Seeley are both AG cases.
Yeah, the King is a election case.
Oh,
The other one is the child support. Let's see. Then we need an interpreter on Mendez. There should have been an interpreter. I don't know if we have. back on the record in the matter versus Miss Swain. Okay, so I do have a pre-sentence report. Did you get that, Miss Krushansky?
Just check it. Oh, just came through, so. Once it reads the attachment, I'll be able to read through.
Okay, any need to make corrections, updates, or deletions, council?
We have none at this time.
Okay, there's a mention of restitution in this amount. What is the restitution being sought?
The restitution we sought is for medical expenses incurred by the victim. Mr. Raleigh and I, after going through the documentation provided of the medical expenses, have come to an agreement that the amount owed is $220.04, and I have a restitution sheet filled out by the approach.
Yes, you may. Okay, so you're stipulating to pay that amount of restitution to the victim? Yes.
Yes, sir.
Okay. I do not have a criminal history. Let's see. You're not on probation, are you? You have any other matters pending? Ms. Duhasky, do you have the Swain file in your hand?
I do, Your Honor.
Thank you.
Would you like me to approach?
Yes, please. Thank you.
You're welcome.
Okay. Okay, I don't see any other assaultive matters in her criminal history. You can make allocution.
Your Honor, I do thank for your recommendations. If you want to note that very recently, senior management course through Crystal Ray, also outpatient substance abuse counseling through Michigan Recovery Services, or MMRS. In other words, she's taking steps to better herself, and I think certainly she has and will learn a lot from this experience. She certainly doesn't want to be in a situation where she is arrested, in jail, on warrant status, anything like that going forward. I think she certainly doesn't want to present that example for her children. And I think with a period of supervision for the court and through completion of these counseling services that she's already enrolled in, I think that could be accomplished.
Ms. Swain, do you want to make a statement? Okay. The report indicates that you met with probation, gave your indications of your perception of what happened. Not surprisingly, but the perception, I guess, from the police reports, I don't believe you received a victim impact statement. Yes, we did. Attached it to the police, to the medical bills, I guess.
This one, I believe, it's on pages 8 and 9 of the PSI would be the victim statement.
Okay.
8, 9, and 10.
Okay, I read the victim impact statement. It was a little difficult to read the handwriting, I'm not gonna lie. But again, it's still consistent. That your rendition is completely different from his rendition. He believes one thing, you believe the other. Nonetheless, you pled guilty to the action that brought you before the court for sentence today, which is one count of assault and battery. I don't have. I think you served at this point, what, 20 days in jail? Is that it? Okay. I don't have, and you're currently employed.
Yes.
Where are you employed?
Exactly.
How long have you been employed there? A year? Okay. And you have 4 children here?
Yes, ma'am.
You have custody of all those children?
Yes, ma'am.
You were with your children on that date?
Two of the children.
You intend to pay the restitution?
Early April.
Okay, and you've already enrolled in anger management?
Correct.
When did you enroll?
I enrolled the morning of March.
Okay, so you recently enrolled? Okay, and how long is it gonna take you to complete that?
I don't know, my intake, so I'm going up every day.
Okay, I see where you were arraigned on warrant on the 13th. Taken to custody the 12th?
Correct.
Released the 13th?
Stayed in jail. I was released today, this morning.
You released today?
Yes.
Why were you still being held? Oh, you had to post the bond, is that what it was?
Correct.
Okay, so she's got about 25, 26 days. Sentence is 25 days, Ingham County Jail, credit time served. To attend and complete the anger management group and provide evidence of that to the probation department. I'm not going to put you on probation because you've already spent 25 days in jail. And you work and you have 4 kids, so you should be busy. Let's see. While you're completing your anger management, you'll be paying restitution. You're gonna pay that in full, ma'am?
Yes. Yes.
Okay, there's a $75 crime victim rights fee that you will be assessed, plus a $50 state minimum cost that you will be assessed as well. Your total is going to be $345. You're gonna pay the $220 of restitution within what, you said 30 days?
Yes.
When are you gonna pay the balance?
And I pay complete balance.
Okay, you'll pay in full within 30 days. Okay, you can pay by coming up to the criminal traffic window and pay there, or you can pay online. They do assess a fee if you pay online, okay? Okay, or you can mail check or money order to the court with your case number. Do you have any questions?
No.
Any additional matters for the record?
I think for the people, Your Honor.
No, Your Honor.
You're all set, ma'am.
Thank you. The victim from the backward case, I want to speak to me. Is it okay if I just briefly?
Absolutely. File. Seven. Okay. Kendall. Okay, record in the matter of the people of the state of Michigan versus Alvin Kendall, file number 24-00058 FY, council appearance.
Assistant Prosecutor Paige Kowalski on behalf of the people.
Attorney Luke, the Public Defender's Office, here to represent Mr. Kendall, who is standing to my right today.
Mr. Kendall, this was a continuation.
Yes.
Are you ready to proceed?
Yes, Your Honor.
Yes.
Okay, you can call your witnesses.
Thank you. People first to call Officer Jeff.
You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury. Thank you. You can have a seat. State your name, first and last, and spell both.
Officer Jeff Kurtz, JEFFKURTZ.
You can proceed, counsel.
Thank you, Your Honor. Good afternoon, Officer Kurtz. How you doing?
Good.
All right. So, where do you work?
Lansing Police Department.
What are your duties?
I'm a police officer on patrol.
Were you working as a police officer on November 16th, 2023?
Yes.
And when you were working that day, were you dispatched to 524 Chestnut Street?
Yes.
Is that in Lansing?
Yes.
Ingham County?
Yes.
State of Michigan?
Yes.
What were you dispatched for?
It was, I don't remember the exact category the dispatches to, but some kind of troublesome subject or neighbor complaint.
And what did you do when you, so did you go to that address?
Yeah.
What did you do when you first arrived?
I remember there was information that the accused in this incident had a gun and threatening neighbors. We set up a contact team near the accused door.
And can you just briefly describe what a contact team is?
Yep, using a shield for cover, a ballistic shield, setting up officers near the door, ordering people out, and the contact, the different people on the contact team are used to secure people as they exit that.
And when you formed the contact team, did people in fact come out of the residence?
Yes.
Do you remember how many?
I would be guessing, be honest, that roughly 3 or 4.
Okay. So after the After the people, or so I should say, when you had contact with the residents, were they allowed to remain in the residence or were they taken out? Or
Nope, once they exited the apartment, they were sought to other officers.
so after they were out of the residence, what did you do?
I stayed by that door, and then eventually an officer came to me and said that we had permission to go inside.
And what did you what did you initially have permission to go inside the apartment to do?
One of the things, at least, was to secure the dog.
Okay.
So that dog into a back bedroom to lock him in his cage.
Okay, and that's what you did? Okay. And when you were did you successfully secure the dog?
Yes.
When you were securing the dog, did you see anything while you were in the process of doing that was notable to you?
Yes. Upon turning around to leave that same bedroom, the dog was locked up. It's the only bedroom in this apartment. There's a walk-in closet. The door to the closet was either open or completely non-existent. I don't remember, but just inside the door in plain view was a shotgun leaned up in the corner. And then as of exiting that same bedroom, go into the common area, there was, read my report, there's either a live round of ammunition or a casing.
So then, and you saw that as you were exiting the bedroom?
Correct.
So what did you do after you exited the bedroom?
Went outside, consulted with other officers.
And then after that?
We got consent to conduct an actual search of the entire.
Do you remember who you got permission to or got consent to search from?
I don't recall, because I believe another officer gave consent, and I was just told about it.
Okay. And so then when you re-entered the apartment, what did you do?
Conducted a search of the apartment. I secured that shotgun that I had originally seen. Secured that either live or spent round of ammunition that I found on the ground. Found some other ammunition and just generally assisted other officers in searching.
Okay. When you say you found other ammunition, where did you observe that?
Aside from the one that was on the ground,
yeah,
there was a box of ammunition on the dresser shelving unit inside that same bedroom where that casing was, in that the shotgun was in that same closet.
Do you remember what type of shells those were in the box?
Not without reading the report.
It
was handgun ammunition.
Okay. And do you remember, was it different ammunition than the round that you saw on the floor? Or was it the same?
I haven't taken that.
And then you said that you then further assisted officers in searching the rest of the apartment?
Yes.
While you were assisting them, did you observe them find anything else notable in the apartment?
Yes.
And what did you observe them find?
Officer Moore found a handgun in the bathroom somewhere in or around the toilet.
Okay. And did you observe anything else? Or did you observe them seize anything else? Or
if I remember correctly, he found some ammunition in that bathroom as well.
okay.
Is it in the bathroom? Was that in the bathroom?
Yes.
And that was you personally, you observed him find that?
I don't know if I personally watched him find it, but he told me about it.
Okay. So then, did you observe anything else of note while you were assisting in the rest of the search?
None of that recall.
Okay. No further questions.
Yeah. Officer Kurtz, you stated when you approached the apartment that 3 or 4 people came out of the apartment?
Correct.
Do you remember if these were men or women or?
A mixture.
Mixture, okay. And do you know what happened to these people after they were let out of the apartment?
I know that they were secured by other officers and taken away from the apartments, so kind of up the half flight of stairs and either outside or no.
Were you with those people or did you stay inside the whole time?
Initially, I was out and I was by that front door of the.
And then at some point, I mean, is it true that you got permission to get shoes for one of those people?
Shoes and to secure a dog.
And to secure the dog, you're sure it was both and not just the shoes?
I remember being told that somebody wanted the dog to be secured in the cage.
Okay, so that may have been the officer, but you're.
Yeah, that's going off what I was told.
And you can't be sure if that, the one round that you found was just a casing or an actual round when you're walking out?
It's in my report. I didn't have a chance to review my report. I apologize. It would be.
And then it was a different officer who got consent to search the entirety of the apartment? And that's when you secured, you said, the shotgun and a box of ammunition belonging to a handgun?
Yes.
Did either one of those have some type of something that would lead you to believe that they were the property of Mr. Kindle, or were they just sitting there kind of off by themselves?
Since I wasn't personally interviewing anyone, I never got a chance to ask who they belonged to.
Further, Your Honor.
I think that's a Polycom. Redirect.
Oh, no redirect, Your Honor.
I need to turn that down.
And this witness could be excused from by the people.
Thank you. Officer, you may be excused.
Thank you.
Next witness.
Thank you, Your Honor. The people next to call Officer Jamil Bakri.
Being in the office, Your Honor, you hear that kind of stuff in the background, somebody watching a video.
Oh, yeah. They gotta build these places better than this. They did, but it's a fake wall. It actually, I think, is hollow, so it makes it echo. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes, Your Honor.
Think you can have a seat? Can you state your first and last name, spell both?
Jamal Bakri. First name is Jameil. Bakri is Bakri.
You can proceed, counsel.
Thank you, Your Honor. Good afternoon, Officer Bakri. How are you doing?
Good, how are you?
Doing good. Where do you work?
Lance Police Department,
And what are your duties?
patrol officer.
Were you working as a patrol officer on November 16th, 2023?
Yeah,
And on that date, were you dispatched to 524 South Chestnut?
I was.
And what were you dispatched for?
I believe that I was dispatched twice. The time in relation to this specific incident, I was dispatched for a complaint of the subject with a gun.
Okay. And so did you go to that address then?
I did.
What did you do first when you arrived?
First thing that we did was render the scene safe, make sure that there was no one in the hallways with a firearm, cleared the building.
And when you did that, did you find anyone with a firearm? And so what did you, after you made sure that the building was good, that the hallways were clear?
One of my partners made contact with the caller, and after that, we ended up setting up on apartment number 2, as that's where the accused was said to be.
Okay. And so you said that you set up outside number 2?
Along with other officers, yes.
Okay. And so what did you do after you were all positioned outside number 2?
I stood in the line, other officers knocked on the door and basically called people outside of the apartment.
Did people exit the apartment?
Yes,
Do you know how many?
I don't recall how many.
Did you speak with anyone who was inside the apartment?
I did.
And who did you speak with?
Brianna Bermudez.
And so she said that she lived in the apartment?
Yes.
Did she say if anyone else resided in the apartment with her?
Objection, Your Honor, this is hearsay at this time.
Objection. Do you want to respond?
Yes, Your Honor. I would just argue that it would be excluded from the rule on hearsay under MRE 1101 B8 as it is a hearsay statement of preliminary examination that speaks to use, ownership, property, or right to use. Residency would be right to use property.
Objection overruled. Can you give me the last name of the person again?
Bermudez.
Bermudez, okay.
You spoke with Ms. Bermudez?
Yeah.
And she said that she was a resident of the apartment?
Yes.
Did she state whether, if there were other people in the, who were residents of the apartment?
She did.
And did she state who?
She advised that Alvin stated.
Okay, did she give Alvin's last name?
I believe she did, but I don't recall it.
Okay. And when speaking with Ms. Bermudez, did she give officers permission to go into the apartment?
She did.
And why did she, was it for any specific purpose?
Yes.
What was the purpose?
She advised me that there was a shotgun inside of the apartment. The shotgun had been said to have been used the first time that we, or had said to have been seen the first time that we were called out to that address. She advised me that Alvin was a felon, and I advised her that because of his felon status, that he couldn't be around them. And she was allowing me inside to collect those.
So then at that point, did you or other officers enter the apartment?
Yes.
And what did you do then?
I continued talking to Mr. Bermudez at that time.
Okay. And then while you were continuing to talk to Mr. Bermudez, did she state who the shotgun belonged to?
Yes.
And who did she state it belonged to?
She gave a few different answers. She advised at first that it belonged to her. Then she advised that it belonged to Alvin's brother. She didn't give his information. And then I believe she advised that it was Alvin's.
Okay. Did was that the order in which she said who had owned each thing? So she the last person she said owned it was Mr. Kindle?
Yes.
And did Ms. Bermudez, did she state if anyone besides her and Mr. Kindle lived in the apartment?
I don't recall.
And just to be clear, you didn't participate in any of the search at all?
No, I did not.
Okay. No further questions?
Cross-examination.
Officer Beckley, did you ever see anyone in possession of a firearm on this occasion?
I did not.
Did you ever step foot into the apartment?
I did.
Okay. Did you find anything while in the apartment?
No.
Did you ever see Mr. Kindle in possession of a firearm?
I did not.
And you stated that Ms. Bermudez at least told you multiple different people were owners of the shotgun?
Yes.
Did you see did you check to see if this gun was registered to anyone?
I did not have it, but I didn't touch the firearm.
Okay. Okay, you saw that people came out. Do you recall how many people came out of the apartment?
I do not.
Was it more than two?
I believe so.
So multiple people were coming out of this apartment after, did the officers like announce this is the Lansing Police Department, please come out?
Yes.
Okay, and after that, then then all of them come out?
Yes.
And none of them were in possession of a firearm?
No.
No further questions, Your Honor.
Redirect.
No, Your Honor.
And this witness be excused?
Yes, you may.
Thank you, Officer Zachary.
Thank you.
Call your next witness.
That is actually the final witness that the people will be calling. And the people, rest of them just make argument to ride over.
Thank you. The defense calling witnesses today.
No, Your Honor, we will not be calling witnesses.
You can proceed to argument.
Thank you, Your Honor. So in this case, we've heard testimony from Officer Donovan Moore, Officer Jeffrey Kurtz, and Officer Jamil Bakri. From the, it was a minute ago, but the testimony from Officer Donovan Moore, he was the lead reporting officer on this case, and he and actually all three officers confirmed that they were dispatched to 524 South Chestnut Street, which is in Lansing, Hingham County, state of Michigan, on November 16th, 2023, because of a report of someone pointing a handgun at another person or some sort of dispute between neighbors. Officer Moore, when they went to the apartment, Officer Moore was the officer who actually spoke with the defendant in this case, Mr. Kindle, and he was able to provide a positive identification for Mr. Kindle. After reading Mr. Kindle has Miranda rights, Officer Moore spoke with Mr. Kindle. Mr. Kindle informed Officer Moore that he had a shotgun in the closet of the apartment, that he and I believe he gave testimony that he also resided in the apartment. Officer Moore then also conducted or took part in the search that was underwent by the officers, and after receiving permission from the other resident of the apartment, Ms. Bermudez. And Officer Moore himself testified that he found in the bathroom of the residence, found a red shotgun shell in plain view. He also testified that he found a small silver handgun in the back of the toilet tank, like submerged in water and hidden. And within that handgun, there was a round in the chamber and 5 rounds in the magazine. As Mr. Kindle himself informed officers that he was a resident of the apartment. Oh, Your Honor, I apologize. Can I also ask, not the correct order of doing things, but I also would ask the court to take judicial notice. I have a certified copy of Mr. Kindle's prior conviction.
That's fine. You could do that as part of your argument too.
Okay, thank you. I apologize. But yes, the certified copy of his conviction.
It will come in under the court rule.
Thank you, Your Honor, and my apologies. So the testimony from officer.
Is this the certified copy or is this a copy of the certified copy? It says certified from December 14, 2022, but it's not raised. The seal is on it.
Oh, I guess it would be a copy of the certified copy.
You want to see it again?
And at this time, the defense would object to the judgment of sentence not being an actual certified copy at this time.
As far as argument goes, I mean, it is a copy of an original document. However, it is signed and does contain, although not raised, the stamp from the circuit court as.
It's not certified, so that's the whole point of the certified copy. It has to be certified. It can't be a copy. I'm assuming that was probably used for another purpose because it was date stamped for 2022. Certified in 2022 as a copy. So maybe that was used up for something else. I'm not sure how your office came about, but typically we would have received it, but it's presumptive as to these previous convictions. So the objection is noted. You can continue your argument.
Thank you. Officer Moore, yes, he testified that he had received permission to enter the apartment, had spoken with Mr. Kindle. It was Mr. Kindle's residence. Mr. Kindle admitted ownership of one of the firearms found in the residence, the 12-gauge shotgun. Officer Moore also testified that he found the several rounds of the ammunition. Count two, the felon in possession, would be satisfied as there would. So sorry. So that by constructively possessing the firearm in his residence where he lived in the only bedroom, in the only bathroom of the residence where he lived, defendant had constructive knowledge of the firearm. And then at the time, he had previously been convicted of a specified felony. The elements for count two have been met. Then, and as well as for count four, which is the felon possession of ammo, which would be satisfied by the finding of the rounds within the within the bathroom found by Officer Moore and observed by Officer Kurtz. Additionally, counts 7 and 9 are felony firearm felony firearm charges that are connected to counts 1 and 2. So the underlying charge would be the felon in possession of the handgun found by Officer Moore and the ammunition found by Officer Moore. And then again, because defendant was in constructive possession of the weapons in his residence at the time, the elements for count 7 and count 9 are satisfied to a probable cause standard. Officer Kurtz then testified that he, when he was securing a dog and getting shoes for one of the people in the apartment, and then later when he conducted the search, that he observed a 12-gauge shotgun in the bedroom of the apartment, and that he also observed ammunition on the ground. He could not remember if it was a live round or not, and then also a box of ammunition in the bedroom as well, which again would then satisfy the elements of the knowingly possessed firearm or ammunition for counts 3 and for counts 5. And then the felony firearm would be defendant being in possession of a firearm while committing those predicate felonies. So the counts 8 and counts 10 are satisfied with probable cause standard. Counts 1 and 6 relate to the felonious assault that the officers were dispatched out for. I believe Officer Moore spoke that he or testified that he spoke with the victim of this incident and received identifying information about the defendant from this incident. But unfortunately, the victim of the felonious assault was unable to be present today. The argument for bind over on counts 1 for the felonious assault, and then the associated account for the felonious assault, the felony firearm for count 6. We would leave those bind over on those counts too. The discrepancy of the court.
Thank you, Your Honor. Starting right away with count 1 here. We heard no testimony from any of the witnesses that a felonious assault took place. They claim that Joseph Shaw Hanley was the victim of this. We've had 2 preliminary exam dates on this file, and this case was previously dismissed when no witnesses showed up. So that was 3 times. This person has never shown up to testify. None of the officers could testify to anything regarding the felonious assault. So we would ask the court to dismiss counts 1 and count 6. Regarding other matters, the prosecution has not provided a I'm sorry, I can't remember the right word here. Certified, thank you. Conviction that would show that Mr. Kindle is not eligible to possess either a firearm or ammunition at this point, which should apply to all of the remaining counts. I would also point out that we've never heard any testimony that he was ever in possession of any of the guns. The officers testified that we got calls about this, but again, the only person who ever claimed to have seen a gun on Mr. Kindle was this Joseph Shaw Hanley, who did not appear. None of the officers ever saw him in possession of a gun. They did find 2 guns in the residence he lived in. They also escorted multiple other people out of this residence after announcing that the police. And it's certainly very plausible that other people who were there were the ones who actually owned or possessed these firearms. Again, there's no testimony that actually puts it in the hands of Mr. Kindle. Officer Kurtz testified that while he did have, did find a box of handgun ammunition, the other piece of ammunition he found, he wasn't sure if it was actually even a live round or not. So there's certainly not probable cause there. I believe, Your Honor, based on the lack of testimony that we've received on all of these matters, that every count should be denied at this point and allow the prosecution to refile if they have additional evidence that comes to light in the future. Thank you.
Okay, today was the conclusion for the preliminary examination that began before this court back on February 9th. And we reset this with the expectation that the witness, the lay witness for count 1 would appear. We've not had testimony from the lay witness. So I think it is without dispute that there's no evidence supporting count 1, correct? Okay, and then we did have testimony from several officers. First testimony taken from, yes, and to move away from that door to having a conversation, please. Officer Donovan Moore from the Lansing Police Department, he testified that he reported to the address of 524 Chestnut, Lansing, Michigan, Ingham County, making venue appropriate on November 16, 2023, in response to a weapons complaint. The description was for a 40-year-old black male, bald, pointing a silver handgun, was what the caller dispatched. Officers Moore testified that they searched apartment 2, searched the kitchen and bathroom, found a shotgun, a round, one shotgun round, and found a loaded silver handgun in the toilet bowl. Officer Moore testified that he spoke with the defendant who matched the description. He Mirandized and the defendant agreed to speak with the officer. Officer told Officer Moore, I'm sorry, defendant told Officer Moore that the only handgun he had was a shotgun. So that would be some testimony that he indeed possessed a firearm if what Officer Moore is telling is the truth. Officer Moore also testified the defendant said that he went to talk to the victim, but stated that he didn't have a gun at the time that he had that conversation. Officers testified that they did do a search on cross-examination. They advised that it was not a search incident to a warrant, but consent was given from the person they identified as Alvin's wife. Officer Moore could not recall who the weapon was registered to, and didn't know who lived at that apartment or was on the lease. The officer testified that he did ask the defendant if he lived there at that apartment, and the defendant did advise that he lived there with his wife, and that the incident with the neighbor resulted or arose from a neighbor allegedly peeking at his wife, and so there was some frustrations. We then had testimony from Officer Kurtz, testified that on the date and time in question, he appeared to the address at 524 Chestnut in response to a complaint, and that he was responsible for assisting with what he termed as a contact team, and they set up a ballistic shield to get ordered everyone out of the residence. He stated that the individuals exited the residence. Officers Kurtz indicated that with the permission to search, they entered the property after securing a dog. Then he said, while securing the dog, actually, there was a closet which either the door was either open or non-existent. Officer saw in plain sight a shotgun. At that time, he stated he also saw a live round while exiting the bedroom. There was consent for search given. He stated he was not clear who gave consent, but that he was advised consent was given. They conducted a search. A shotgun was found. A live spent round was found. A box of ammunition was found. He testified that Officer Moore found a handgun in the bathroom at or near the toilet, as well as some ammunition. Officer Backery testified today that he assisted in response to the call at the address in question on the date in question. He assisted with ensuring that the hallways were cleared. He testified that he spoke with the resident of the unit, Brianna Bermudez. She stated she lived there. She lived there with Alvin, and she indicated or advised the officer that the defendant was a felon, and that in description of the firearm or weapons located, that first she just told the officers that they were hers, then they became the defendant's brother, and then they became the defendant. So the court rule requires, the criminal jury instruction that is, requires that felon in possession of firearm, specified felony at trial, be proven beyond a reasonable doubt. First, that the defendant knowingly possessed, sold, used, distributed, received, carried, shipped, transported, or purchased a firearm, ammunition in this state. Second, that at the time the defendant had previously been convicted of a specified felony. Third, that less than 5 years have passed since all fines were paid and all imprisonment was served, all terms of probation and parole were successfully completed, and fourth, the defendant's right to possess or use or transport or sell or receive a firearm or ammunition had not yet been restored pursuant to Michigan law. The question or the issue that the court has now is that we don't have a certified record, and the certified record has to have a embossment from the court. I'm not sure, Mr. Trustee, if your office requested a certified record.
I was under the impression that we had requested a certified record, and
Okay, well, I think that's the hang up, but I think the testimony, obviously count one would be dismissed. We have counts 2, weapons felony, firearm possession by felon, same count 3. Count 4 and 5 are ammunition, possession by felon. And then we have 1, 2, 3, 4, 5 counts of felony firearm, but one of those counts of felony firearms, count 6 that is, would be dismissed along with count 1. I think that the testimony that was presented would give rise to more than mere suspicion that those crimes alleged were committed, and that this defendant identified in court as the one who committed those actions. But the problem is I don't have a certified record. So I could grant the people's motion to dismiss the case for that, but that would just mean you're gonna reissue the charge. And then we got to start this all over. And I think it's more meaningful to adjourn so that we can get a certified record. That's what the court's going to do.
thank you, Your Honor.
Thank you, Henry.
Thank you. We will adjourn. I don't know how long it takes to get a certified record, to be honest with you. Any idea?
I'm also unsure. But it's the 30th Circuit Courts. I believe it'd be faster than if it was another county.
Is he being held on anything else?
Yes, Your Honor, we just have a matter with Judge Jacob.
Oh, okay. I was gonna say, I didn't know if you needed to address bond, understanding that the assault of action is going to be dismissed, but we don't need to if he's being held on something else.
Yeah.
Okay. Any additional matters for the record?
No.
No.
Thank you. Let me get your date.
We can do April 4th at 8:30.
April 4th at 8:30.
Yeah,
Was it
yeah.
Deshaun Johnson, the one that was
This
in
is
the
like
opera?
I heavily heard a DV like back in the kids.
Can you hear me?
I can hear you.
All right,
Mr.
I apologize.
Your name is Deshaun Johnson?
Yes, ma'am.
You're represented by Mr. Milks?
Yes, ma'am.
Okay, he said that you were continuing to your examination next week. Have you already spoken with him about
No,
this
ma'am.
case?
No, ma'am. I was gonna call him to basically check in with him after this because I had called the pretrial this morning because they called my mom. They reached out to my mom and I basically called. Nobody answered, and I supposed to check in with them also. So I'm just trying to make sure I do any and everything right. I even got my tether on the charger now. I'm just trying to make sure.
You were supposed to check in with pretrial services within 48 hours of your release and then probably weekly. I'm not sure. You probably want to put your cigarette out right now. You should contact Mr. Milks. Is he in the building? He might not be. He's got a big day today. Yeah. Yeah, has he indicated to the court, let's see, that you were going to be continuing to exam. So we'll see you in person next week, okay?
Yes, ma'am.
Okay, and make sure you call Mr. Milks and check in with pretrial services so that you don't get a bond violation between now and then, okay?
Most indeed. May I say something?
You may.
I'm not gonna lie. I am new to the system. This is scary for me. So, checking in and making sure I do any and everything right. That's all I want to do. I make sure I charge my tether box. I don't get in no BS. I don't go to the Carter's 3200 South Washington where I'm trespassed from. I haven't been in contact with nobody. It's just I'm willing to put, I'm willing to put all energy and effort into getting to the bottom of this. You feel me, the right way. And I'm not gonna lie, I am a little scared.
Okay, well, reasonably so. You're being charged with a serious felony. So I'm not going to discount that there should be or is some anxiety as it relates to that. I will say that you have a really solid public defender who's representing you. And so you have no areas of concern from the court's perspective as it relates to someone that would zealously advocate for you. So you should be in contact with him. I would leave him a voicemail. Make sure you leave your phone number so he make sure he has an up-to-date phone number for you. I don't know if he's in the office still. I know his wife has a big day celebration today, so he may not be in the office. And then you follow up with pretrial services today, okay?
Yes, ma'am.
Thank you, and continue to follow your bond conditions, okay, sir?
Most indeed.
All right, thank you.
All right, now.
Mr. Har, you said it's Pfeiffer's, okay.
Hart is Pfeiffer's, Har is mine.
Oh.
So
Hart is Pfeiffer, Har is yours, okay.
Yeah.
Har is president, okay. Who's his attorney?
Miss Robinson, I saw her in the hallway when I went to get the officer and see if she's.
Am I good to leave or still stay?
Yeah, nope, you're free to go, thank you.
All right.
I see someone identified as Tim's iPhone.
Yes,
What's your full name?
Timothy Allen King.
Okay. Is your attorney logging in separately?
He is logging in. I'm just waiting on him.
Okay.
Robinson is in front of Judge Flores on the record. It sounds like they just got started on the
Oh, did she speak to Mr. Har?
I don't, they were like on the record. I just asked another one of the attorneys in there if they'd gotten started recently or not. Wanna.
Are you Cody Har? What's your name, sir?
Cody is with me. I am his primary caregiver. My name is Marcus with Community Mental Health. Here's
Okay.
Cody.
Okay, we're waiting for his attorney. She's on the record in another matter. I see there's a message. There's a message that was sent in the Zoom live chat,
So that would be,
stating
I sent that.
request that scheduling be emailed. We don't email schedules
Okay.
from the court. And then additionally, a preliminary exam must be held in person.
Okay. Okay, thank you.
Okay, and once his attorney is available, he'll be able to meet privately with her.
Okay, awesome. Thank you.
Thank you. Mr. Brown?
Yes, ma'am.
Okay, did you speak to your attorney?
Yes, ma'am.
Okay. Okay, your attorney said that we're continuing to exam on that matter, so you're all set for today. We'll see you next week.
Okay.
Thank you.
I'm in court. I gotta stay with it. Next month.
Good afternoon, Mr. Perone.
Good afternoon, Your Honor.
Are you representing Mr. King?
Yes.
Okay. Ms. Logan, are you there?
Yes, I am, Your Honor. Good afternoon.
Good afternoon. Okay, on the record in the matter, the people of the state of Michigan versus Timothy Allen King, file number 23-02216 FY, council appearance.
Good afternoon, LaDonna Logan on behalf of the people.
Jacob Perone on behalf of Timothy King, who's also present via Zoom.
Okay, and so today's the date and the time that was scheduled for a competency review. The court is in receipt of a report from the Department of Health and Human Services Center for Forensic Psychiatry. The report was dated for March 11th, 2024. Did the parties get a copy of that report?
I did, Your Honor.
Yes, Your Honor.
Okay. Any reason to make any objections to the body or conclusion of the report? The opinion of the examiner is that Mr. King is competent to stand trial at the time of the evaluation.
None for the people.
None for the defense at this stage, Your Honor.
Okay. The court will, without objection, adopt the report and incorporate it into the court record. The matter will be entered with an order of competency, and he will be set for a preliminary examination alongside the next faction of preliminary examinations scheduled May 28th, 29th, 30th, 31st, June 3rd, 4th, and 5th. At what time?
I'll start at 8:30.
At 8:30.
Thank you, Your Honor.
Thank you. Any additional matters for the record?
None for the people.
Nothing further, Your Honor.
Thank you. You're all set.
Thank you, Your Honor.
Take care.
Thank you. Have a good one.
Go to business.
Thanks, Mr.
You have an interpreter?
Yes, we do.
Okay, very good. Record in the matter of the people of the state of Michigan versus Nico Pendez, file number 24-00739. Council appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
You're muted.
Oh, sorry. Your afternoon, Your Honor. Maurice Davis, P 76203, appearing with Nico Pendes, who was present appearing via Zoom.
Thank you. And we have an interpreter. Please state your name for the record.
Mahbuba Feda.
Raise your right hand. Do you solemnly swear or affirm that you would interpret in the matter before the court completely and accurately and not divulge confidential communications to help you God?
I do, Your Honor.
Thank you. Today's the date set for a probable cause conference.
Danas mi smo ovde da gledamo slučaj.
This matter is currently scheduled for preliminary. This matter is scheduled for preliminary examination on March 28th at 9:30.
Ona druga sud bude 28. marta o 9 sata I 30 minuta.
Are we continuing to examine?
Judge, I received the discovery. I was recently retained on this matter. I received the discovery, had a chance to review it today. I want opportunity to review it with my client. So I'm asking the court if the court will consider setting another PCC date for now.
Okay, we can treat next week as another probable cause conference.
And this next week at 9:30. Anything available in the afternoon?
No.
And we can appear via Zoom, correct?
You can appear via Zoom.
Great.
Okay, and then we'll address the timeline at that time.
Kada 28. kad vidimo da pričamo dalje vreme.
Does the defendant have any questions for the court?
No, Mr. Pendes, is that the correct dialect for the interpretation?
Nico, razumete sve što ja kažem?
Da, pa razumem ću valjda.
Yes, I understand.
He said yes, he understands.
Okay. All right, thank you.
Okay, any additional matters for the record?
Nothing from the people.
Imate neko pitanje, kaže nemamo.
Nemam.
Okay, we'll see you next week via Zoom.
Sledeće nedelje u Zoomu opet ćemo vidjeti vas. Dwayne Osman.
I'm not sure what he said.
Log off.
Šta se rekao, Rejan, Niko?
Nisam ništa rekao.
Yes, I didn't say anything.
Oh, okay, thank you, you're all set.
Hvala puno.
All right, thank you.
Thank you. Yes. Is Seeley here, Justin Seeley?
Yes.
Okay, on the record in the matter of the people, the state of Michigan versus Justin Michael Seeley, file number 23-03457, council appearance.
Yeah, good afternoon. For the record, my name is Mark Burke. I'm a Special Assistant Attorney General, appearing on behalf of the people.
Marcus Baldori appearing on behalf of the defendant.
Okay, today was the date and the time that was set for a probable cause conference on this matter. How are we proceeding on this?
I can speak to this. My client plans to waive the preliminary exam in this matter. We had reached in January, actually, an agreement to essentially, we had an order for payment of bond executed. This is a failure to pay child support case, and there's going to be an 11-month delay, essentially. But in the meantime, we're going to proceed to waive the preliminary examination.
Okay, you intend to do that today, or you want to do that next week at the time of the exam?
We can do it today, Your Honor, if that's okay.
Is the state waiving their exam as well?
We are, Judge. Yes, thank you very much.
Mr. Seeley, do you understand that you have the right to have a preliminary examination on both counts 1 and 2 of child support failing to pay?
Yes, ma'am.
You understand the purpose of that exam?
Yes, ma'am.
So you have the right to require the prosecution put forth evidence that would establish probable cause that a crime was committed and then probable cause to charge you with the crime. You understand that?
Yes, ma'am.
You're willing to unconditionally waive your examination?
Yes, ma'am.
Anybody make any promises to you if you waive it?
No, ma'am.
Any threats being made to you?
No, ma'am.
Your bind over date's going to be April 3rd. That's the date that the circuit court's gonna get the file from this court. You do not need to appear at circuit court on that date, okay? You will only need to appear there if your attorney for some reason files a motion for you to be rearranged in circuit court. Otherwise, your next court date will be a pre-trial in circuit court. Your attorney will be advised of that next date, okay? Do you have any questions for the court? That's for you. I'm looking at you.
Oh.
Do you have any questions for the court?
No, that's fine.
Okay, any additional matters for the record, counsel?
Not for the people, Judge. Thank you.
I don't know if that's directed to me as well.
Any additional matters for the record,
Yeah.
counsel? Yes.
Yeah. We might, if you direct, we can handle this at the circuit court level. There's a condition of the pretrial release order that I would like to get adjusted in regards to the no contact. I have a motion to terminate the no contact order that I can file today. Essentially, it conflicts with an order in circuit court currently. There's an order for my client, the defendant, to be doing co-parenting counseling with the mother, who's the subject of the non-payment for child support. There's an order for them to be attending co-parenting counseling. That order was entered in the fall of last year. There's been no negative incidents between the two of them in the time preceding. And then this complaint was brought, or these criminal charges were brought, and there's a no contact in it. And I have the Judge Koenig's order from circuit court. I have that here with me today. And it does order that they have co-parenting counseling.
So they're in counseling.
They were, and then based on this no contact,
No, this process third-party contact allowed for minor child, that would include counseling. Says it on the order. Because the counselor would be present.
Your Honor, I'm just, maybe I'm not understanding, but the counseling is directed for them to both be in attendance at it.
Correct, they can be, third-party contact would be allowed for the purposes of childcare is what the order of the magistrate was.
Okay.
That's what it
Okay,
says.
thank you for the clarification.
Yep, so that would not be a violation of his bond.
Okay,
condition.
understood. I didn't know that. Thank you.
Yes, any additional matters? No other matters?
No other matters, no. Thank
Okay,
you.
you're all
Not
set.
for the people,
Thank
Judge.
you.
Thank you very much.
Thank you. You're welcome. Mr. Lee, which matter are you here for?
Your Honor, Mr. Kristen and I wanted to speak to you off record in regard to trial scheduled for next week, Tuesday, whenever you get a chance this afternoon.
Okay. Ms. Robinson, did you speak to her?
I did, Your Honor.
Okay. On the record, in the matter of the people of the state of Michigan versus Cody Har, phone number 23-03462. Appearance, please.
Assistant Prosecutor Paige Petrosky on behalf of the people. Aaron Robinson, Assistant Public Defender for Mr. Hard.
Okay, today was the date Mr. Har set for a probable cause conference. And this matter is scheduled to continue to preliminary examination next week, March 28th at 8:30. Are we continuing?
Your Honor, at this time, I'm going to be raising a competency motion for Mr. Har, and I will file that paper or that paperwork later today. So I would just request that it be taken off the docket for now.
I assume there's no objection to that, correct?
No objection, Your Honor.
Note that in the file, and we will take it off the record once we receive the paperwork.
Thank you, Your Honor.
Thank you. And did you speak to his caretaker?
I did.
To make sure he has information. I think there was a request. He needs things emailed. Did he get you that email?
I have his contact information and I will reach out to him to get all of.
Okay, very good.
that.
Okay, any questions on behalf of Mr. Har?
No, we are good. Thank you, Your Honor.
Thank you. You're all set for today. Did they ever put Christie on? Okay, let's see. On the record, in the matter of the people of the state of Michigan versus Matthew Christie, file number is 23-00612 FY. Mr. Christie, this matter is being set for review, and that's because we have the outstanding issue of your sentence from July 2023, where you were sentenced by the court to 365 days Ingham County Jail with credit for 3 days, and you were to go to inpatient treatment. And my understanding is that you did go, or you were at least released for inpatient treatment, but the court doesn't have any information indicating that you completed treatment. So did you complete treatment?
There was a family matter where I felt I had attended my baby mama's son.
I unfortunately can't understand. Can you speak a little louder, because I can't make out anything that you're saying?
I didn't get released to there. I have so now I'm not intoxicated. But I did go to it, and I was going to, and a family matter came between us. When my baby mama was pregnant with my son.
We're gonna have them come check the Polycom, because we can't hear you on this end, okay?
Okay.
Okay, is somebody here from Woodside Meadows? No? Oh, they're supposed to be here at 2 o'clock.
On September 15th, when I got released from Simmons, I did not complete that course. I did try my hardest, but I had to do a family matter.
Okay, so you didn't complete treatment?
No, I went and I had a family matter from.
Okay.
My baby mama was assaulted, so I attended to that.
Hi, Judge Simmons.
Hi.
Checking in on the Greer case. Sorry, I'm running late. I have the property manager here too.
Switch them.
Okay.
They said they're gonna move them rooms. Hey, can you guys talk in the hallway?
I'm so sorry.
Thank you.
Can you hear us now?
Yes, I can hear you now.
Perfect.
Okay, thank you. Okay, Mr. Christie, you were stating that you attempted to complete the treatment, and then what happened?
My baby mom was texting my baby mama on the computer at House of Commons, and she said she was assaulted. And I felt that I felt to go take care of that. When I got there, she was assaulted again. And then it was my fault that I did not check in with Miss Brianna, and when I was not aware she was working at the courthouse. I thought she was working at the Veterans Memorial Courthouse over at 303 Kansas. That is my fault that I did not check with her.
Okay, I will note that here on the file, because we did not receive a completion, so we knew that I think that was why this file was in limbo. And that is also why Ms. Otten was not even in a position to complete an order of probation for any remaining term. But understanding that you failed to complete the treatment, you'll be remanded to the custody of the jail for the remaining term of your sentence.
That is July 6th, correct?
Excuse me?
That is July 6th, correct?
Yeah, I'm just not sure how many days credit you have. The jail will have to update me, because I don't know when they discharge you to your treatment. And then
No, September 15th,
they discharged you September 15th.
correct.
Okay, we'll get a confirmation from the jail, but you will obviously get credit for that time. You're just completing the sentence, the remaining term of the sentence in custody, okay?
Okay, can I request can I reopen this case and find it?
I'm saying, say it again.
Requesting to reopen this case from the very beginning of the two felonies that it was, and to find it with a lawyer.
I don't understand anything he's saying. Are you
requesting-
able, can you stand up and walk closer to the Polycom?
I am requesting to reopen this case back from the two felonies that originated from and fight it from my standpoint with a lawyer.
No, you're not in a position to reopen the case. What you can do though. Thank you. If you can look into any right of appeals that you have, if you haven't exhausted the timeline to file an appeal. But you can't just reopen the case absent an appeal, sir.
Okay.
Thank you. You're all set. Let me see.
Ms. Williams said the property's been pig tagged for a year. Do you know the exact date?
I don't know the exact dates of the pig tags.
Okay, but what you do know is that Mr. Greer and the occupants of the premises have not been paying rent since April.
Correct.
Do you know if money has been placed in escrow?
I
for
don't
that?
have any notes of escrow account.
Okay. And could I go back to the maintenance requests question? Because I believe that if there are business records being kept, that would be a hearsay exception if they're regularly kept that way. In other words, if she has business records from the landlord and she's relying on those records, that would be an exception to hearsay.
I don't care about the business records. I adjourn this so you can bring a witness to address a pink tag issue.
Yes, Your Honor. I don't have any other questions then for Ms. Williams, Your Honor.
Did you have questions for this witness? Okay, thank you, Ms. Williams. Okay, did you want to give some testimony or something? Were you calling another witness? I'm sorry. For the pink tag issue?
I suppose I would call Mr. Greer. But I think in the last hearing, we already sort of addressed most of that.
As it relates to the pink tag, because you did call him at the last, or you did question him at the last hearing. The issue that I adjourned for really just pertained to pink tag. There's no dispute that he hasn't paid any rent. That's not
I
disputed.
see. So no, then
The dispute was whether or not he had a lawful reason to withhold it because of issues at the property. Property's been pink tagged. He submitted some inspection records at least from code compliance. And now we got testimony that's been pink tagged for at least a year, although I do see where it was some issues that were noted from the rental inspection from 2022. So you wanted to give testimony, ma'am?
Just in our counterclaim, I included a screenshot from the city's website. It was pink tagged 5/5 of 23. And then we do have photo evidence with the actual tag on our window.
Okay, do you have also evidence of the issues at your property?
We do, yes.
Okay, and you showed that to plaintiff's counsel?
Yes, I gave a copy.
Okay, you can provide those.
This is a copy. This is a
Yep,
copy.
yep, those are,
So these
that's
are
your
for us.
copy, yep.
Okay.
And then I do have some emails, an email between Tammy Allen, who worked at the property, and some work orders, one showing that it was just canceled, never completed, and then.
Is this the tag on the window here?
Yeah, that's the neighbors, the red.
I was gonna say that's a red tag, not a
Yep.
pink tag.
The first photo had the pink tag on our window.
Yeah, the unit right next to us has now been red tagged.
So I see pictures of a window. That was one of the issues you're saying?
No screen.
Yep, the ceiling of the windows are really bad, and then a lot of the windows don't have screens.
Okay, front door, what's going on here?
It's poorly sealed all the way around.
Yeah. It's when it rains a certain direction, it leaks inside the door.
The critters get in.
Yeah, that's the biggest.
What kind of critters?
All of them.
Spiders,
Ants,
stink bugs, fox elder bugs,
roaches, earwigs. Those are
front door jam.
That's where I think a lot of the creepy crawlies get in through there because it's just they can just walk right in.
Yeah.
Front door. Kitchen window, what's the issue here?
The screen is poorly fitted.
Okay. Again, I see kitchen window, poor seal, ill fit screen. What is this? Bathtub surround?
Yeah, so that gash was in the bathtub surround when we moved in. They had caulked it with regular caulk, which came undone maybe a month after we lived there. We ended up just flex sealing over it so we could continue to use the shower. That was almost 3 years.
Yeah, because when the shower ran before that,
Is this your tub?
Yes.
Yes.
Did it look like this when you moved in?
It was beginning to. It was they had glazed it and it was bubbling up and stuff. So it just started chipping as soon as we moved in.
Okay.
That's the current.
Did you
state
make
of
a
it.
complaint about this?
Yes. And I did give an email with that work order from 2021.
Window sill. Looks like just needs to be recaulked. Is that what's going cleaned and recaulked?
Yeah, that's the bathroom window. There's no screen in that window either.
No screen. Okay, back door, is the door closed here?
Yes,
Okay, so I can see the light coming through. Is
Yes.
that was what you're trying to
This
do?
is one
Yes.
issue that they say that they fixed too since we began litigation.
and ever since we
Okay.
moved in, it's been like that.
So the majority of the issues were revolving, at least from these pictures, around the windows not having screens, or they weren't properly fitted, and then similar issues with the door.
Yes, correct.
Okay.
Front
And then
back
I
door.
see the only other issue I see that you presented is a tub issue, correct?
Yeah, I think the sink is the one that was in the code compliance, the kitchen sink. You can take pictures of the sink. So there's like, there was no sealant on the sink area whatsoever. Insects crawled in and out. So I flex sealed that whole area of the sink, and that was in the code compliance.
Okay, I see where you were put in a request for the bathroom tub shower on October 31st, 2021.
And that, it was
Is that what
actually
this
also
is?
in the initial checklist, which
Yes.
we weren't able to obtain from our subpoena.
Okay, I see bathroom tub shower status went from open to closed, January 17th, 2022. That's what you submitted here. When did you take these pictures of the tub?
This morning.
Oh, okay, and then June 2021, units, you asked for screens throughout the unit.
Yeah.
Okay, and then there's an email. Who's Bernard?
It's me.
Okay, that's you. Tammy Allen, who's Tammy Allen?
She was what Miss Fallon is now today.
Okay, that's who you replaced, ma'am?
I did not. I
Oh.
replaced someone else.
Because it's 2022, so of course, right? Okay, I'm trying to see where this starts. Let's start it back here. Okay, so it looks like he's been requesting service on his unit since 2021. I don't see any evidence that's, he requested that tub be fixed. And do you have more than one bathroom at this apartment?
Yes.
With one and a half.
1.5, oh, so this is the only tub?
Yes.
Our children have never taken a bath since we've lived there.
I wouldn't. Let's see.
Your Honor, they said earlier that when they moved in, that it was not in that condition.
It was, they said, no, they said that it was beginning to be, and they were starting to peel. I don't even know how, I don't know what this tub is made out of. I don't know if it's porcelain. I don't know how it's peeling like this. Did you see the picture?
I believe so. We have the same copies in the student. Okay.
And you should have before copies from first complaint, third complaint, 12th.
I didn't get.
I'm sorry.
I don't have the emails, but.
Correct, but,
That's been every.
and so something clearly, I mean, their testimony that it was beginning to deteriorate in this fashion is corroborated by their request for the tub shower to be addressed October 31st, 2021.
And it actually was in the move-in checklist.
Yeah, I don't, that's your testimony and I don't dispute that. And then that request, they show here that your client closed it. But this picture shows me that they didn't do anything. They just closed it.
I don't think I've seen that. I take your word for it, Your Honor.
I can show you what they just submitted these. I can show you those. They closed the work order and then they sent an email that says, hey, we have a concern that we think our work requests are getting deleted.
It says open to canceled. Then this one is. This is following request has been created regarding the screens, yeah.
And the screens are still here, so I'm just gonna be quite frank, and cut to the chase, because we've already turned into a very informal proceeding at this point. These pictures are telling, but I don't think they tell the story that you should have withheld your entire rent. I definitely agree that your rent should be abated because they neglected to do the things that they were supposed to do. And with the pink tab, you have the right to escrow all of your rent until they get the property into the condition that it's supposed to be in. And as of today, I have no evidence that would allow me to see that they've done that. So you still aren't paying any rent?
No, we got 4,000 in escrow.
No, but so you've been escrowing your rent now,
Yeah.
but prior to that, you were not escrowing your rent. The
No.
past due rent is how much?
14,521.
14,521.
And that is inaccurate, by the way.
What makes you believe it's inaccurate?
Because we were being charged 1,100.
1,100. They were
Yeah.
charging us 1,100. I had also subpoenaed an itemized statement, which we did not receive.
Yeah.
We have a
You have
ledger
one?
right here.
You have a
that
ledger?
can see, yeah.
You can provide them with a ledger. I'll allow you an opportunity to review your ledger.
Thank you.
There are also charges on here that were taken care of when we caught our rent up in April of 2023.
See that?
I do not.
Evidence of what? What charges are you talking about? I don't have a copy of the ledger, so I can't.
There are
follow
late
along.
fees on here going all the way back to December of 22.
Okay, didn't you have an email about that? So, one of those emails you submitted?
That was about, yeah, the month to month charge.
Okay, no, I thought there was an email, he was concerned about late fees. On the back maybe of that email.
There are no late fees on your account as far as your account being over, yeah, so.
What date was that?
That email was June of 2022, so that was prior to this.
Okay, so we know as of June 22, you had no late fees. Okay, and so then you fell behind in your rent again?
Yes.
Okay, and so you're saying that you got caught up? When did you get caught up?
March of 23, we were completely caught up, and then we also paid our April rent of 23. We made the April late charge.
I need a ledger.
I would agree to, but prior to that.
We have, yeah, thank you. We only have 2 copies of this right now, Your Honor, and there's. I don't know if you guys can. Or I can follow along on her ledger, but if they need a copy, then.
Okay, I see late charge $75 from 12/6/2022. But I don't even see where their rent was assessed on this ledger for 12/2022, like January 2023 or February. Why do I only see late charges?
Your Honor, I'm not sure if that's because the partial payment was made, and so the late charges are what remained on as a balance, as a carryover balance. I'm not sure.
Well, I'm looking at the other months and it's shut month to month. It shows the amounts. So it says, let's see, month to month rent $777.38. What is this ledger? Is this ledger of money that's being brought in? I'm not following. Or is this money owed?
This letter looks like money that is owed.
Okay, so they owe $75. Is that what that amount tab is?
So yeah, that's a late charge. That $75 is a
Got
late
it.
fee.
Okay, so they paid the rent, but they must have paid it late is what this is saying. So there was just money owed for the late charge.
Yeah, or if there was, if it wasn't paid in full and there's still a balance, that'll create a late fee as well.
Correct, but that balance would have showed up on this ledger though.
Correct.
Okay, so this just says a late fee. So that to me lets me know or assume that they paid in full but didn't pay it on time.
Correct.
Okay. And so it looks like that was, when is their rent due? Because they look like they get a late fee on the 6th of every month. Let's see.
I believe the grace period is until the 5th. And those late fee charges drop on the 6th of the month.
Okay. And then I see as of yeah, I see that you said that your testimony is that they paid rent April 27, 2023. I see as of May 1st, 2023, that they still owed $777.38 plus a late fee. And then I guess everything else would show no rent, late charges, trash income. What is trash income?
So they pay separately for like their utilities, like water, trash.
Oh, okay, so trash income just means it's the trash
Correct.
payment, okay. Water, sewage fees, okay. You've not disputed that you haven't paid any of these bills from at least April of 2023, though, that you've conceded to that already, correct?
Yeah, that's when they've been pink tagged.
I understand that, but I'm trying to understand why you believe that they were overcharging you.
Oh.
On this ledger.
The $100 month to month, the extra $100, they charged us that all the way back to our signing our second lease in December of 21. We signed our second lease.
What is the month-to-month charges that they're referencing?
From what I know, if you're not in a current lease, those month-to-month charges are added, which is $100 a month.
Per the lease agreement, if they didn't sign a new lease, then their rent goes up to $1,100 per month.
And I see those month-to-month begin in 2023, June, I think. Let's see.
This lease came to an end on February 28th, 2023, Your Honor.
Okay, well, there's a $100 fee in June. Were they in a lease?
No, they haven't signed a new lease since 2022. So they're on a month to month right now.
I know, but they signed it in 2022 and then it ended when in 2023?
It ended on February 28th, 2023.
Oh, okay, well. So that explains the $100 fee.
They were charging the additional $100 from 22 to 23 as well.
I don't see that on this ledger.
This ledger doesn't start until December of 23.
Correct, but you paid that. You didn't dispute it? Because that you must have paid that. We're here about the rent and dispute.
Right, we have paid it, yes.
Okay, so you were
We had
paying
been
the
paying it.
$1,100, and so they're still charging the $1,100. I don't have any reason based on this to believe that they've overcharged you based on that. You just testified that they had been charging you that and you paid it. But then they've also clarified that there's an additional $100 month-to-month charge when you're outside of the lease agreement. So right now it says that your rent is $14,521 past due. And you're reflecting to the court that you only have $4,000 in escrow, correct?
Correct.
And that still leaves a past due amount of $10,521. I think, however, based on the concerns, and I only have issues as it relates to, I only see issues as it relates to ventilation. I clearly have a major issue with this bathtub. Ventilation, there's a pink tag, obviously. And your door issue, I'm trying to see what this pink tag code compliance says here. It states here. There was a handrail missing in the basement. An issue with the stairwell in the basement. Light fixture is loose, hanging with some exposed wiring. Large accumulation of combustibles in the basement. These were issues that were also noted in May of 2022. It says service panel lacks proper access. A furnace was cited due to age and or condition. And a qualified contractor that is registered with the city needed to visually inspect the furnace. It also cited the furnace lacked the clean filter. It says the closed dryer vent was improperly installed. And it stated that there was duct tape being used on the dryer vent, which would be inappropriate. It states here, all windows and exterior doors, including storm windows and doors, needed to be weather tight and in good repair during the months of May through October. Every opening directly from the dwelling unit to the outdoor space shall have supplied screens and self-closing device, and every window or door with openings to the outer space used or could be used for ventilation shall otherwise be supplied with screens. That's an issue that was not addressed from 2022 as well. It cites gaps around the bottom entrance door. Another issue that had been cited from 2022. It says that there was a returner supplied air registers that were clogged or dirty and required cleaning. Again, issues that had been previously cited the year before. The countertop in the kitchen was noted as being deteriorated, damaged, and lacked non-absorbent capacity. It says there's water damage to the drywall on the ceiling. In the first floor bathroom, it talks about a guardrail being damaged again in the basement. Second floor, it talks about a handrail, hardware for the bedroom doors damaged off hinges. Toilets were loose. Bathtub enamel chipped. And again, the bathroom sink. I think that, are you gonna make any further argument at this time?
Your Honor, I have nothing to add to the record.
Okay, and I think, you guys submitted all of your argument. Did you have anything further to add? Okay, as I indicated, even at the last court date, I think that it's undisputed that rent was not paid from the time of or since April of 2023. The amount that the plaintiff is alleging is now owed is $13,576.07. If you include April, it says $14,521.07. With court costs, it's $14,676.07. There's an issue of a pink tag property that's still not being brought up to code. More concerning is the issue that there were multiple requests being made for the same, for items to be addressed that were even cited in the code compliance notice that was attached to the complaint, and they went unaddressed. I don't believe that the issues that I am reading outside of the furnace issue, and I don't have reason to believe that the furnace, well, I think I asked you at the last hearing that the furnace been addressed, and you said it was. I don't believe that the things that I'm seeing would cause for a full abatement of the past due rent. If you didn't like the conditions or the issues that were going on there were being unaddressed, then you had every right to pack up your family and leave. Or you could put your rent in escrow to show good faith. And I mentioned that to you last time. You don't just get to hold on to your money and spend it however you want, or say, well, I had hard times and I had to pay other bills, but then you didn't secure your rent money in an escrow account, and you're supposed to escrow it with the court. Nonetheless, I believe that your rent should be abated. I'm going to abate first a third of your rent overall due because of the issues that existed, some of them since 2021, which you provided documentation that you requested to have those issues addressed, and there's been no evidence that they were ever addressed. And to the contrary, there's some evidence that they were completely ignored and or some of those requests canceled. That's the first issue. I'm also waiving all of the late fees that are on this ledger. Because how can they be charging you a late fee when they don't even respond to your request to fix something so you can take a bath in the unit that you're residing in? So all the late fees will be waived. I believe there is 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18. I see 18 late fees, but I'll let our counsel confirm that for me.
Including the ones from 2022, Your Honor?
Absolutely, because there were requests for some work to be done at the property since 2021 that the record would reflect was never done.
Your Honor, I'm seeing 16. Maybe I counted wrong.
Yeah, I just counted 16, so I think you're right. I'll I am abating all the late fees, 16 at the rate of $75 is $1,200 plus 1/3 of the overall past due rent will be abated, $4,473.66. And that's from the total of 14,676.07.
Your Honor, I'm sorry, I just want to make sure I'm writing down the numbers as well. So we have $14,676.07
owed.
And then
I'm abating 1/3 of that, so that's $4,473.66. That I might have done that from the without including April.
Excuse me, Your Honor.
Give me just a moment. We're doing math here and we're attorneys. Okay, actually, it should be, I have 1/3 is $4,892.02. What did you want to ask me, sir?
Is there any way I can get a brief recess? I gotta use the bathroom.
You can feel free to go use the restroom.
Thank you.
Okay, so that's right. 1/3 of the total past due for April will bring us to $4,892.02 plus $1,200 and court costs will be waived. That leaves a balance of $8,584.05. You can do one of two things. You can escrow your rent in full and continue to escrow into the court or to the property is brought up to code and the pink tag is removed. Or you can pay all of that rent and just continue to navigate the maintenance requests and issues that you have, or you can vacate the property.
Your Honor, in terms of so at this time, the court's not entering a judgment for possession, if I'm understanding correctly. You're simply saying that at this time, 85,8405 is owed, that money should be paid into escrow with the court.
If they're going to stay in the property.
Okay.
Yeah, because you're not getting possession of the property, it's pink tag, they don't have to pay you any rent. They have about half of that in escrow right now. So it's up to them if they want to continue to escrow.
I would say though that they're saying that they're escrowing the money, Your Honor, but as you had put it earlier, you said that the money should be paid with the court.
It is, it's here.
It's escrow here.
What, I don't, you have that in the
It should
court
be in,
records, Your Honor?
it should be in JIS. At least that was the order that I gave, an order that he was supposed to escrow it here back in December.
Okay.
Yeah, oh, 4,000.
Yeah, so it's escrow here. So at least since the order's been entered in the court, they've been operating in good faith as it relates to the escrow order. And the reason why I'm giving this option is because this property is still pink tag, its issues are not being addressed. I adjourned the matter to allow you to bring your client that can address the issue, and no charge to her. She's new. She was thrown in here after working here for 2 weeks. She doesn't know what's going on with maintenance and why they didn't get this stuff taken care of and why they didn't prioritize it when they know it's tied up in court. She can't answer those things. But it's up, and they've also indicated that they want to leave. They want to vacate this property. I don't understand why landlords, when you have issues such as code violations and matters that were not addressed for years at a time, don't privately go and make agreements to try to negotiate so that you can get these people out of here without calling attention to this, because I can guarantee you, you look pretty well put together. Would you take a bath in that tub? Absolutely not. And you wouldn't either. And to come into court and think that we should make people live under those conditions and pay market rent, I think it's a bit deplorable. And so that's got to change, but it starts with landlords and people who own all these properties to follow the law and to keep their properties up to code. So I think that if they want to buy out and leave, they should have the right to buy out and leave and not have their credit messed up when they've been living like this at least since 2021.
Your Honor,
So they can, so they can, like I said, continue to stay here, escrow their rent, but their rent, it's going to be abated at $8,584, or they can vacate the property.
Okay, so but do you want me to prepare an order? Your Honor?
I'm not, I was waiting for him to come back so she can talk to her husband about whether or not they want to continue to escrow or vacate, because that's going in the order.
Okay, Mr. Honor.
We'd like to vacate.
How quickly can you vacate the property?
If we're basing the run off April, by the end of April. And been attempting to vacate.
Okay, so the defendants will vacate the property and turn over the keys no later than April 30th, or pay $8,584.05 to the plaintiff to continue to maintain possession, or you can escrow that amount, which you have $4,000 in escrow now, while you continue to hold over the property. But you're not going to continue to stay and not pay. But you, based on what you provide to the court, I believe you should be let out of your lease and you should be allowed to leave without having your credit messed up.
Your Honor, and do you want me to prepare the order?
Yes,
I'm
please.
assuming, yes. I will prepare again, move out date April 30th, 2024. Rent has been abated to $85,8405. And do you want just so I understand, then box 1 would then be checked, right? Or would we not check that box? Because you're saying that the plaintiff does not currently have a right to possession. I want to make sure that
You can check box 1, because if they're gonna hold over the property, you gotta have a recourse.
Okay.
If they don't move.
Okay, so I do have an order prepared. There are numbers already in there, but I can put the correct numbers in and then put the move out date.
That works.
Okay.